Welcome to the board's January 30th to 31st, 2019 board meeting. A belated Happy New Year to all of you. My name is Victor Law. I am the president of the board. As I call this meeting to order, I would like to advise all members of the public, both present or watching the meeting's webcast, that the board is a consumer protection agency subject to the Open Meetings Act. Members of the board may be using an electronic copy of the meeting materials. So please be advised that such members are using their devices for this purpose and are not communicating with each other via email or other electronic means. And I would like to remind everyone present who is interested in receiving continuing education credit to remember to sign in and out on the designated sheet at the back of the room. The meeting is being webcast, so we respectfully request that when called upon to speak, please come to the speaker's table and speak directly into the microphone. This will ensure those individuals watching the webcast are aware of all discussion and action. As part of its meetings today, the board will hold a special meeting as authorized by Government Code Section 11125.4A2 to consider proposed legislation. It is expected that this special meeting will convene following the report by the Enforcement Committee. Also, as indicated in the agenda, the board will convene in closed session. Upon conclusion of closed session, the board will reconvene in open session and will adjourn the meeting in open session. This portion of the meeting will not be webcast unless the board will consider any other open session agenda items. I thank you all for attending, and I look forward to a productive meeting. And now I would like to take a roll call and establish the quorum. And let's start with Alan from the right-hand side. Oh, let's please remind all of you that we could only use 4 microphones at a time. That one there is already active. So among all the board members, only 3 people are allowed to touch your microphone. So if you're not speaking, please turn it off. And when you do, then you touch on the microphone. Okay, go ahead, Alan.
Alan Shad, professional member.
Debbie Veal. Maria Serpa, licensee.
Albert Wong, professional member.
Lavanza Butler, professional member.
Greg Lippy, public member.
And I'm Victor Law, professional licensee.
Stan Weiser, professional member. And Mr. President, if I might ask a question, and the attorneys may have to verify this for me, but Government Code Section 11.01.41, I believe states that if a room where a meeting is being held bears the name of one of the board members, then the board member conducts the meeting. And I noticed that we're in the Stanley room.
I'll have to take that under advisement. We'll get back to you after a break.
Thank you very much.
Ricardo Sanchez, public member.
Okay, so a quorum has been established. But before we proceed to the next agenda item, I would like to request a moment of silence to remember Dr. Kathy Webster. Dr. Kathy Webster was the founding dean of KGI Pharmacy School, and she was instrumental in having the accreditation of KGI Pharmacy School from the beginning. She was very well respected by the students and pharmacists because of her accessibility and also cooperation with all the professionals. Unfortunately, she passed away last month. So everybody, please bow your head for a moment of silence. Okay, thank you very much. All right, let's go on to agenda item number 2. Public comments on items not on the agenda and agenda items for future meetings. I see we have somebody here already. Go ahead.
Yes, sir. My name is Fred Mayer. I'm a registered pharmacist, state of California for 65 years, graduated at UC San Francisco. I'm representing Pharmacist Planning Services, a 501c3 consumer public health pharmacy organization. I'm also representing a group called California Alliance for Retired Americans with 1 million California consumers. I have 3 quick questions in my time, 3 minutes. You tell me when I'm up. The first thing is, our senator in Marin County, where I'm from, asked me to come before the board. His name is Mike McGuire, Senator Mike McGuire, and he represents all the way from San Francisco to the Oregon border in the marijuana district. And what he'd like to mention to the board, if you haven't heard, the Lizzie Law, L-I-Z-Z-Y. The Lizzie Law is a 15-year-old dog went into a veterinarian. The veterinarian gave the dog an antibiotic. The dog died on the table. And the person who lives in our county and where I live at Smith Ranch became so bereaved, said, why didn't you tell me that the antibiotic would kill the animal? It did kill the animal. They introduced the Lizzie Law. It passed. It's signed by the governor, where it mandates that all veterinarians will give counseling on all drugs to their pets, their dogs, cats, animals, sharks, or whatever their veterinary they're dealing with. So the question I have is, one, can we look at this at a future agenda item? The Lizzie Law, if veterinarians must counsel, we have the over 90 that says that pharmacists must counsel. They're not counseling, and how do we know that? From the World Health Organization and Food and Drug, and also the Cite and Fines, which my students document. So we're having a problem there, and so I'd like that out the next agenda, if I could, the Lizzie Law for discussion. The second thing, real quick, Mr. Chairman, is the CBD oil. I got the CBD oil. Can we look at CBD as a consumer advocate? We're very confused. We're buying CBD oil in every store for all kinds of things, from cancer to arthritis, and we need it discussed more. We're very confused at the Prop 61, Prop 64 rather, that says that that we can dispense it with.
This item's going to be discussed tomorrow, later today on the
Right. Okay.
interim executive officer report, and our
Right.
Attorney General will also have an update
Right.
on that item. So
The only third thing, very quickly, is errors. I'd like errors on the next prescription, the increase in errors, agent, and the oversight. Who here is going to be oversight on prescription drug errors? And the CARA group is especially concerned about that. They see lineup of people in the chain drugstores and the independent community pharmacies, and they're not counseling because of stress and pressure, and we'll get talking about that sometime else. And I'd just like to introduce my colleague here, Mark, who would like to talk about prescription errors and the need for it to be on the next agenda. Sorry.
All right, thank you.
I'm
Go
here
ahead,
just
Mark.
to make sure Fred, if he goes over 3 minutes, I get him 3 more minutes.
Okay.
So my name is Mark Rouse. I'm a pharmacist since 1984. And yes, I'd like to see the discussion of prescription errors on the next agenda item. And we'll be back here later for one of the other agenda items. And thank you very much.
All right, thank you, Mark.
You know, Mr. President, can I just ask maybe a clarification as far as prescription errors? You know, just exactly what, so we can make sure we hit, you know, what you are hoping to have us discuss.
Very briefly, Mr. Chairman, we came before the committee 3 years ago when Walgreens and 3 chains were cited $500,000 for failure to counsel. Look at the screen, in 3 counties, San Diego County, Alameda County, and San Bernardino County. They were each fined $500,000, 3 plus or minus. And then just a year ago, our store called Target that was taken over by CVS was fined by the district attorneys. We went to our Marin County district attorney in Marin County, and we showed them what's going on in Marin County with the lineups and the failure to counsel, and the CVS's, the Walgreens, the Rite Aids that we have. And we've got an investigation going, and the problem seems to be the staffing. And again, I've been before the board, and we brought students before the board. We've written 4 articles. So you need to do a little bit more. And I'm not sure calling together a committee to look at manpower, looking at the number of prescription metrics, but somehow we got to, as a consumer advocate, the errors are increasing, And part of it is the fact that the pharmacists, I'm over time, what the consumers in Kara says, Fred, we went in and we documented what's going on in your local Safeway. There's a pharmacist, one pharmacist, and he's trying to give shots. Nobody else behind the counter. He's got a sign saying closed because he's over there. The phones are ringing. Nobody's answered. They got a lineup of 10 people, and they're trying to give shots. They have to give so many shots. They have to answer the phone. We've now got this new accreditation business with the cures, and there can't be the consumer advocates. It's a lose-lose for us because they can't be in 4 different places at once. And I'm not sure what your issue is, but you either need more help or you got to get some qualified techs, or we got to get somebody to take the pressure off because it's increasing the errors. And we had this study 10 years ago they called a manpower study that your board put together. So what you got to figure out, I'm not smart enough, how you get more staff in there to take the pressure off because the pharmacist can't answer the phone, give the shots, do the insurance, go answer these questions when the person walks up like in the Safeway, they have secret shoppers. Where's the artichoke, young man? You're trying to give a consultation. So the question is, how are you going to do this? I don't have a clue. I'm a consumer advocate. I'm being harmed. And it's your job to protect the consumers. That's your #1 mission. And I don't see you doing that.
We'll have the
So
enforcement
I've
committee
overstepped my
check on
time. I
the patient
apologize.
consultation piece.
I
Yeah.
apologize.
Thank you.
I didn't mean to talk so long, but if you can figure out what to do, you people are brilliant. You'll
Thank-
figure it out for us old people.
Thank you, Fred. Come on up.
Good morning, board members. Danny Martinez with the California Pharmacists Association. I'd like to request the board to agendize an item related to, and I know this is not the board's purview, but just hear me out, related to insurance companies and PBMs. Right now, when there's a transfer of ownership of a pharmacy, the contracts that the old pharmacy has with the insurance companies and PBMs they don't carry over to the new owner. And so the new owner has to rework all that stuff, which is not what I'm asking. What the problem is that there's no timeline in statute as to when they have to actually have these contracts done. And what we're hearing more so in the last couple of weeks than anything else is that they're taking such an inordinate amount of time that it's affecting continuity of care of patients. So when pharmacists or when pharmacies have a new owner, patients can no longer go to that pharmacy because they know that they're not going to be able to provide prescriptions, and it's causing patients to not get medicine. And so I was wondering if we could ask the Legislation Regulation Committee to agendize an item to look into this, possibly for a statutory change in the law to at least instill a timeline as to when that has to be done, so that to ensure continuity of care for patients.
A little more specificity there, Danny. I'm not sure how our board can address this.
Well, so when there's new, when
Well,
there's,
I understand that.
Okay.
I'm with you there, but what are we controlling?
and I don't know, maybe this is something that can be discussed. This maybe perhaps a specific, because the board has the board has an interest in patient care.
Oh no, I
protection of the patient.
understand where you're going.
When they are provided with examples, and I'll have some of these if this gets agendized, when there are examples of patients who can no longer access their pharmacy because there's a change in ownership, because either the insurance company or the PBM has taken so long, sometimes over a year and a half, to finalize contracts, pharmacists are not willing to provide those scripts because they don't know if they're going to get paid for them if they don't have an existing contract. That has a patient care component that I think, and perhaps we can talk about it, that the board may be able to address at a future agenda.
Sounds like a question for our council.
She'll get back to you at break.
Really?
I was kind of wondering if, is it managed
Are you
healthcare
the council?
that governs PBM?
That's starting January 1st of this year, that's correct.
So have you had a chance to approach them?
We
or
are
is it-
also approaching them. We're trying to hit everything we can right now, just because, as I mentioned, in the last few weeks, we received a number of phone calls of pharmacists who are concerned that their patients are either being lost to other avenues or they're just simply not getting their meds because they can't get this thing worked
Yeah,
out.
I kind of agree with my esteemed colleague here that that's probably where we need to start.
Okay.
So I don't know what the legal question is, but I can tell you sort of politically that when PBM legislation was wending its way through the legislature in the last couple of years, there were and the Board of Pharmacy was maybe going to have a role in, administering or enforcing against PBMs. They were specifically taken out of the bill. So, that's the legislature's view of who should be regulating it as the Department of Managed Healthcare. Whether that controls everything that you do is another question, but that's sort of who's supposed to be regulating them.
So therefore, there's nothing we can do.
Well, but if you want to put any teeth into it, it has to go through sponsor legislations to do anything about it. Otherwise, we have heard a lot of consumers complain because they could not get the medicine through the pharmacy that you should go to because of language barrier, transportation, or whatnot. Because the transition of owner, then they cannot really go back to the old pharmacy that they visit. And there's no regulation in place that would help them in any way. So I think as the Board of Pharmacy, we should take a look at it through the legislation committee and see what are the ways that we could help them in achieving that.
Can we do that?
Yeah, and on the board's agenda later today, we are going to be talking a little bit about some of the PBM legislation. And so this might fit with that conversation, and then the board can decide then whether or not to refer it to committee.
Okay.
Mr. President, Steve Gray, I would like to support what Danny has put forward, that this be on the agenda. I know that as pharmacists and many of the other people in this room are not really familiar with some of the nuances of health plan and insurance company law, but California has long had in the law, the statutes that govern health plans and insurance companies on coverage, continuity of care rules. And we've had a problem because of the lack of understanding that can and should apply to pharmacists as well as physicians, hospitals, clinics, and other things that are in the network. For an example, if a physician is in an insurance company's network and then that physician leaves that network, patients still have a right of continuity of care from that particular physician for a reasonable period of time. And so the insurance company has to have a contract with to cover that with a claims company. And likewise, we have pharmacists that happen to be prescribing pharmacists that get caught in this all the time. And the results can be deadly. We have patients that lose their coverage with a particular health plan who are on Coumadin, and then they've got to find another pharmacist. Meanwhile, that pharmacist isn't getting paid, even though the law says there's a continuity. So I would say, yes, this should be on the agenda because it does affect the practice of pharmacy and the practice of pharmacists also.
Okay, thank you. Yeah, we will take a look into it. Any other public comment for future agenda items? Board members, public? No? Thank you. Okay, let's move on to agenda item number 3, the approval of the October 23rd to 24th board meetings minutes.
I have some corrections.
We have some. I think we have some corrections.
So I know that one of the there's
Yeah,
corrections.
go ahead, Debbie.
There's corrections made in the licensing committee piece. But then also I have page 29, end of item D. Ms. Sodergren asked if the board would like staff to find an author to clean up the APP language. I thought the board voted yes, but it didn't seem like that was indicated there.
We can review the tape and,
Okay.
and update it as appropriate if that's agreeable to the board.
And then on page 31, the committee recommendation should say as well versus it currently states as wells. And then on page 50, the second paragraph after the fund condition in the middle, it says the name Debbie. I don't remember who it is. I don't think it was me, but I thought we might want to include the full name of who the Debbie was.
Well, I have also one corrections too. On page 11 of 62, on the motion, I think Stan was present there, but then on the vote it says not present. It went on the. Is it on the? That's on the. Oh, that's on the October, right? Oh, okay. So October Stan should be absent. That should be absent. Okay. Oh, not on this one. I think it's on the other on the other minutes. Not on this one. All right. Only for the one that Debbie mentioned. Any other corrections? If not, I need a motion to approve as amended.
So moved.
Motion by Greg.
So you actually had a motion and a
Oh,
second?
second.
So
Yeah.
But he has to
do
change
you want to
his
withdraw,
motion.
Change the-
withdraw your motion just to make it a real clear record?
Okay.
Okay.
Or amend your motion, yeah.
Amend the motion.
The power
by-
of having
by
the
Stan.
room named after you.
All right.
So he amended his motion, I second.
And Greg second the motion as amended. Any other comments by the board, by the public? If not, all those in favor, please raise your hand. Okay, anybody abstain? No? Okay, motion carried. And let's move on to agenda item number of the board minutes of agenda number 4 is the December 14 board minutes. And I do have one corrections here. It says the location is in North Vermont, Los Angeles, on the first page.
On North Vermont Avenue.
It says U of Southern California, but at 590 North Vermont. Which I think that was in Irvine.
Yeah,
Right?
it was.
Yeah, so that's correction over there.
Okay.
And let's see. And at that time, yeah, then we have Stan Weiser present, but then on the vote it says not present. This is page 6 of 7. Page 6 of 7. Stan was present, but then on the vote it says support 9, but not present was Stan.
Right.
There's only 2 corrections that I have.
Okay.
Anybody else?
Motion to approve as amended.
Motion by Greg as amended. Did a second? Second by Albert. Any further discussions? By board members and public? If not, all those in favor, please raise your hand. Okay. Oppose? Abstain? Okay. Motion carried. Okay, then let's move on to. I gotta change this. All right. Agenda item number 5, recognition and celebration of pharmacists licensed in California for 50 years. Do we have anybody in attendance that you have the license for over 50 years? Seeing none. Okay, then we have to move on to the next one. Agenda item number 6, Enforcement and Compounding Committee report. Chairman is Mr. Alan Schack. Alan?
Okay, let's see here. I'm getting feedback over here. Is this clear for everybody? Oh, okay, good. Okay, thank you.
Wow.
I've had enough feedback, thank you. Okay, for the members of the audience, remember the following is what was discussed at our previous committee meeting. Our next committee meeting is on March 14th. We'll have a broader agenda attempting to discuss a variety of sunset issues and clarifying other issues. This report, I have 13 exciting pages to read, 7 motions, and 14 bills to discuss, plus other items. And to make sure that you're listening, I'm going to read some of it twice. And so, okay.
If we hear it, can we raise our hand?
Yes, exactly.
And then
Just,
you'll stop.
yes. Okay. First, discussion and consideration of implementation strategies for chartered legislation. At the September enforcement. Enough comments, all right? I had no sincerity in that. At the September enforcement meeting and October board meetings, members of the public suggested that the legislation passed in this year's legislative session be brought to the committee for discussion. The first, AB 2086, Controlled Substances Cures. The background is that this law allows prescribers to request a list for patients for whom they were listed as being prescriber in the cures database. As part of the public discussion, clarification was sought on whether cures allows an individual to be both prescriber and dispenser. Board staff will confirm that those that this affects may be listed as such. Additionally, staff will ask the DOJ if the list will be provided by the requester by email, post, or fax. Was there follow-up on this by the staff? Beg pardon? Oh, okay. All right, and attachment 1 is a copy of that. The second bill is AB 2783. It is controlled substances, hydrocodone combination products, schedules. This simply reclassifies hydrocodone combination products as Schedule II controlled substances, making California law consistent with federal law. And attachment 2 contains a copy of this. Item number 3, AB 2789, speaks to prescriptions and electronic data transmission. This requires that by January 1st, 2022, all written prescriptions issued by licensed prescribers in California be issued as electronic transmission prescription, known as an e-prescription. Also, all pharmacies, pharmacists, and other practitioners authorized to prescribe or dispense furnish this medication must have the capability to receive an e-prescription. The law also allows for approved exemptions to this law. The committee discussed who is responsible for ensuring that prescribers provide e-prescriptions to pharmacists. The board staff confirmed that the board would not provide regulatory oversight to the prescribers for this law. The committee also reviewed the list of approved exemptions. As part of the public discussion, the committee was advised that there are concerns regarding the DEA letter from 2017, which states that pharmacists pharmacists to forward unfulfilled electronic prescriptions from pharmacy to pharmacy, including Schedule II drugs. However, there's no mechanism to do this. Board staff is requested that a copy of this letter be sent to the board, and additionally, public sought clarification of the terms forwarding and transferring. The committee directed board staff to work for DCA counsel on the limitations that exist within the regulation and bring back recommendations to the committee. SB 1447, automated drug deliveries. Yep. Maybe I should ask for public comment. You can comment on those other former things too.
Steve Gray is an individual pharmacist. On the bill that was just discussed regarding prescribers having to do electronic prescribing, I noticed that in the notes it said that the conclusion was that the board has no responsibility for that. I would just remind that the board has a lot of pharmacist prescribers out there, and I don't think that they are necessarily going to know that they have to also become electronic prescribers by the deadlines of this bill, just like any physician, dentist, other prescriber. So I think the board does have a responsibility to communicate to its licensees that this bill applies to them as well. And I think most of them would know that, but there's always somebody that doesn't get the word, and it takes quite a while to set up those systems. And the pharmacists that I'm thinking of, many of them are independent practitioners. They do not work for a major organization which is going to supply them with the electronic prescribing, DEA-approved electronic prescribing software, equipment, et cetera. So I think there is a role for that in there. And then I also noticed that there was a request for the letter from the DEA,
Right.
or communication. I believe that was sent to the staff, and I was wondering, now is that going to be also republished in the newsletter or something so that the confusion is resolved regarding the transmission of unfilled Schedule II prescriptions?
Go ahead, Ann.
So two things. The first is this law will be included in the newsletter, talking about new laws. So hopefully people will be reading that and recognizing whether it applies to them. I believe that the comment was, do we have enforcement authority over the majority of prescribers? Physicians and surgeons, osteopaths, and we do not have jurisdiction over them. So just to clarify that. With respect to follow-up conversation, the committee directed us to work interim, and then it will be brought back to the next committee meeting as part of the agenda, I believe, based on the chair's direction.
Okay, so so when would it be brought back? And that answers that question. There's also some confusion that you might want to put on your enforcement about whether the electronic prescribing also applies to prescribers in hospitals. When a patient is discharged, they get a discharge prescription. When they go on pass, they get prescriptions, and these are often filled from chart orders, because there's a chart order exemption that's been around for many years for hospital prescriptions that are dispensed directly to the patient. So I think that also would probably need to have a discussion on how this electronic prescribing law applies to hospitals for discharge and pass prescriptions.
Oh, that's a good point. That's a good point. Another good point, Steve.
So, Alan, so right now for the electronic prescription, e-prescription can accept Schedule II. Can the other prescription be transferred from one pharmacy to the other?
Ann?
So what we're looking at right now at the staff level is we're looking at what the CFR provides, and then we're also trying to coordinate with the DEA, because it's our understanding that there may be changes to the rules with specific to the transferring and the refilling. There was, at the committee meeting, there was discussion about what happens if a prescription is e-prescribed to a pharmacy and then the consumer wants to go somewhere else. How is that remedied? So that's part of the research that we're conducting right now. And then our intent is also to reach out to New York and the DEA on the East Coast as well, because they already have this implemented, and see how they have addressed some of these challenges. So we should have hopefully some good answers for the next committee meeting.
Yeah, good. I think these are some of the questions we need to clarify for all the practicing pharmacists as these questions come up in the future.
Right, and I appreciate this conversation, because that was the focus of this meeting, is clarification of the legislation. So it works out well. Okay, SB 1447, automated drug delivery systems. Okay, with 1447 and AB 2037, these bills establish requirements for automated drug delivery systems. The registration and licensing program that recognizes different uses for such devices. This measure prohibits the ADDS from being installed, leased, owned, or operated in California unless specific requirements are met. Additionally, drugs can be stored for a period of 48 hours in a secured room with at the ADDS location. The bill authorized pharmacy inspector to inspect all locations pursuant to the provisions. Lastly, this measure requires the board to report to the legislature regarding the regulations of these machines on or before 2024 as part of the board's sunset evaluation process. The committees considered providing more specific storage and record-keeping requirements. Board staff were directed to research options and present policy recommendations to the committee. Additionally, the committee considered whether the board should develop regulations regarding mandatory reporting of quality assurance reports. So let's see here, to keep in chronological order, we've got two motions mentioned here. Hang on a second here. So we have to have the committee recommendation is a motion to direct board staff to work with the committee chair in developing regulation language for consideration regarding the mandatory reporting of quality assurance reports to the board. The proposed language will be brought to this meeting. So do we have to pass that?
I think that was direction to staff to do the work.
Oh,
that you
okay.
need to do, and the language is in
Okay. And so the update is consistent with the committee's recommendation. Attachment 4 contains the draft proposal approved by the chair. Should the board agree with the proposed changes, the following motion could be used to initiate a regulation change. Attachment 4 is in the midst of the two published bills, and I've looked it over. It looks good to the chair. If anyone else wants to look it over, that's fine.
So that's the committee recommendation.
Right. All right.
Any discussions with other board members? Comments for board members? From the public?
Okay.
Seeing none? Okay, because we all those in favor of this motion from board members, please raise your hand.
Arguably, you need a second. You
I
need
need
a
a sec-
motion
oh,
and a
that's the
second
committee.
because the
It's a committee recommendation. You don't need a
the
second.
committee didn't have the text.
Oh, you
Okay.
need to read the whole text?
Oh,
No,
no,
you
no,
don't.
no.
You don't need to read the
Just need a
text. It's
second?
just that because the text is being brought for the first time, I would recommend that it be a motion and a second.
And a second? All right, so I read, all right, we need somebody to motion that first.
So moved.
Moved by Greg.
I do have one question, and maybe I'm looking at the wrong part of attachment 4, but a lot of times it says it becomes operative on July 1st, 2019, and occasionally it says it becomes, there's like cutoff dates. Can you just explain why I understand why we have the effective date, but can you just explain some of the cutoff dates?
So I can try in concept. So there were two pieces of legislation, AB 2037 and 1447. And so to harmonize the two requirements, sometimes you had to stagger the implementation. There was challenges because AB 2037 had urgency provisions. So some of that took effect immediately. But that same section was being touched and amended in 1447. But those provisions don't take effect until July 1 of 2019. Right. And so you had to allow provision for the 2037 provisions to take effect immediately and then recognize additional changes to the sections taking effect July 1, 2019. And that's why it's sometimes it's a provision is in effect for a limited period of time and then replaced with something different.
Okay, thank you.
All right, so it's motion by Greg and second by Stan. All right, any other public comment? If not, all those in favor, please raise your hand. Unanimous? Okay, all right. Motion passed.
All right, now AB 1753, Controlled Substances Cures Database. This reduces the number of security printers approved by the Department of Justice. Further, this measure requires security prescription forms to contain a unique serialized number that must be reported to Cures and establishes reporting requirements to the DOJ on the delivery of security prescriptions to the prescriber. As part of the committee discussion, the committee was informed that the board requested that the DOJ delay implementation to the provisions since the approved forms were not going to be available by January 1st. Senior Deputy Attorney Joshua Estag Room, street name, yes, confirmed that printers would not be able to provide compliant forms to prescribers by the effective date. SDAG Room presented to the committee proposed subscriber alert which detailed the proposed options for pharmacy. As part of the public discussion, a member of the public questioned if applicable relating to the serialized number provision in the law. This was clarified that it's only to be used in reporting to Cures, not in the prescribing or dispensing requirement. Further, it was stated that the section 11164A is the provision that requires that of January 1, only a prescription with the new security features is lawful. A representative of CRA and NACDS noted that the discussions with the author's office has confirmed that the intent of the author was to allow for a broader application of the if applicable, and offered to work with the board to find a solution. Ms. Harold suggested enforcement discretion and not to make this enforceable for the board, not to make this a priority for enforcement for the first 6 months of 2019. Following the meeting, the board released an approved committee statement detailing that the enforcement committee of the board was recommending to the board that the EO not make investigations into non-compliance security forms as specified to be an enforcement priority. The board staff monitored the implementation and took several steps to assist patients and pharmacists during this transition. Specifically, board staff were redirected to respond to questions over the phone and in writing. The board released correspondence from Assemblymember Lowe, the author of the member, wherein the intent of the legislation was detailed. The board staffed with the Department of Justice and the Medical Board to release a joint statement intended to clarify the position of respective agencies, as well as the entity's role in enforcement. In addition, the board staff developed FAQs, and this was sent out via subscriber alerts and posted on the website. Attachment 5 includes a copy of the subscriber alert, the joint statement, the FAQs, and the letter from Assemblyman Lowe, and a copy of the approved language for 1753. There's a motion here to ratify the enforcement of the committee's recommendation clarifying the board will not consider this an enforcement priority until July 1, 2019. Now, board, we should have some board comment on this.
I'd like to ask a question. Thank you. Although I don't want to preempt anything that you feel would be appropriate at this time.
Go ahead.
Okay. It really gets to the timing of all of this, and many of us have had calls from professional members, members of the profession, regarding the situation that they've been put in by this legislation and their inability to provide their patients comfortably with the class of drugs that this impacted. And so I'd like to step back a few steps from where we are at this moment, and I guess it's more of a question of the ledge committee, or it's certainly not enforcement, but were we ever invited to be involved in this legislation by the author? And if we weren't, what is our position with regards to legislation such as this that has such a huge negative impact on the consumers of California? And I mean, somebody spoke about, Danny did, continuity of care. I mean, it was just, the calls that I got from pharmacists, the frustration was huge. And you try to assure them that the board, was taking a position on it where we understand, but pharmacists are real hesitant for a variety of reasons, and maybe it's one of the reasons is their perceived ideas about the board and how they may be dealt with.
If this is the bill that reduced the number of printers to 3, and we did oppose that bill. So, we had some say, but it didn't do much.
Yeah, so I'll say a couple of things. First of all, you anticipated an update that I was about to give, which is that the same legislation, same author and others has, as of January 24th, did a gut and amend of an existing bill, AB 149, that's supposed to correct this issue. So I think you knew that already, but I just wanted to say that. I don't think that should have impact the board's action. I think until that legislation is passed, we are where we are, and the board should still do what it wants to do with the committee's recommendation. But the second thing I'll say is that, as Greg pointed out, the board did take a position on 1753. I don't think anyone anticipated. So what actually happened was that the prior version, the last time that the security prescription forms were updated, there was a grandfathering provision in the statute that said, you know, the new forms will be required as of January 1st, but enforcement won't begin until July 1st, essentially. And I don't think anyone anticipated that that provision was not going to be carried forward into the new version in this, and somehow it was struck and no one noticed it. CMA was heavily involved in writing this legislation, so I think everyone was assuming that CMA was watching that particular issue, since prescribers would be the most directly affected by that. And somehow it just, either it was done at the last second and no one noticed it. I don't know exactly what happened, but I think everyone agrees that this was just oversight, or lack of oversight, whatever you want to call it. But it was an oversight, not to forward that language, to include similar language in the bill. I think the author believed that there was language in the bill saying that the Department of Justice would have some discretion. I think there was some misunderstanding about how effective that language would be in terms of the enforcement dates that are because the Department of Justice is not the enforcement agency with regard to, you know, the prescribers or the dispensers. That language was not as effective as maybe the author had thought it would be in terms of delaying implementation of the bill.
And we also issued a letter that basically we were not going to prioritize this. So I think we need to now ratify this recommendation.
Right. I mean, hopefully that will happen. I don't think anyone here is likely to speak against it, but I do agree that it's generally a good idea to ratify things that you've already done.
So our next special meeting will address this issue, but I think we just want to have it on record that this board support the committee recommendation.
Right.
Well, certainly, but you know, if this comes up again, is there something that we can do that to be more effective? I mean, lots of people were really inconvenienced, and while we did send out a letter saying that we would not make it an enforcement priority, that is not a convincing letter, and that's not a convincing statement. And I'm not.
And some pharmacies are refusing to
absolutely.
fill.
Many of us got calls, you know, saying what could happen, and I feel like you know, maybe we focused in the wrong place, and I'm not sure how. And if this comes up again, where is there any ideas of what we can do, Josh or
Well,
Ann?
So if I can, so the author's letter, and the reason that we have it posted and we disseminated it was because it really did speak nicely to the policy and how they believed it should have been effectuated. And so that was sent out because the author's office was explicitly stating what the intent was and where they believed there was flexibility. Decisions were made to not implement perhaps the way that the author had envisioned. So some of that is a little difficult to identify when you're going through the legislative process. However, this will absolutely be something that we will be watching for moving forward and ensuring that if this type of transition does take effect or there's changes in this capacity again, we will absolutely be advocating that there be a transition period moving forward. I think there's been a lot of public comment in this area on this legislation from numerous stakeholders, all of which were caught by surprise with how it was actually implemented. When we're required to enact something, we typically have to do regulations to provide clarification on how we're actually going to do it if the statute is not self-executing. And I think that there are some that believe that the statute was not self-executing and that regulation would be required to identify some of the parameters, and that implementation approach was not taken. Not by us, but by others.
But it sounds like there was a provision in the original bill and it just got dropped. Is that correct?
Yeah, I mean, the original, not this bill, but in the previous time that the previous legislation that had amended the 11162.1 to add the previous round of security features that were added.
Okay.
At that time, which was I think 2008.
So it never got into this bill and
Right.
then got dropped later.
Right.
So when there is a glaring issue, such as this bill had or didn't have, other than opposing, do we have any other options available to us? Or I realize that this is a democracy and it's legislation, being proposed and voted on. But do we have any other options available to us where we can inject our concerns?
I mean, I think we could raise concerns with Ledge Council to say that, because the Ledge Council is supposed to be the office that, reconciles bills, looks out for these kinds of problems that they might create. So we could certainly raise those concerns with Ledge Council.
Wouldn't it also qualify under the continuity of care that they were talking about?
That's putting, well, that's
Putting too much liability on the pharmacist.
well, you bring up the issue, and as was mentioned, it's continuity of care, and I'm sure every pharmacist thought that, but they were too scared to do anything. But because they thought their licenses were on the line, the DOJ said it's going to be implemented, and our reassurances weren't enough and weren't strong enough. And so I feel that in a certain sense, we bear a large part of the responsibility and we weren't sharp enough to make action. And that's not an implication of staff or anything else. I'm talking about the board members ourselves. We should have been more aware and been stronger on this. I hate it that the patients were impacted. Oh, how about some public comment?
I am, is it on? Mark Rouse again, pharmacist since 1984, and I am a full-time pharmacist, and I had to deal with this issue on a daily basis. I had prescriptions come from other stores, some of our own stores, saying, they wouldn't fill it, the store down the street, will you fill this? I had phone calls from other pharmacies because I'm a union rep, so they contact me to get information. Hey, Mark, they don't call the board, they call me. And it was a nightmare to go through this. Patients getting out of surgery with their Norco prescription. You can't get a hold of the doctor and get it changed to Tylenol with codeine. They're off to the next surgery. They're in pain. So it was a very bad situation. We got mixed signals from my boss is back here, by the way, so hopefully he won't hold this against me. But we had mixed signals even from our supervisors, saying, well, you don't fill it. And then you guys even bring up the other discussion is, what happens if we do fill this? I did fill some, okay, and some I called doctors' offices and got documentation they're going to fix this. But what do you do when you get audited now 3 months down the road and they pull these prescriptions and say, hey, you filled an unlawful prescription. We're taking away your money. That's another issue we have to look at too. So it was awful. Patients suffered. It was and it's an ongoing nightmare. There's still pharmacists out there says, hey, the law still says what it says. I'm not going to fill this. And it puts us in a bad bind. So I just want to pass that on. Do you have any questions for a full-time pharmacist? There's probably not too many here. I should be at work today, but I got coverage.
Well, so will our ratification of this help?
I would think so. Not everybody reads emails. They walk into the store and you're already 50 prescriptions or 100 prescriptions behind. You may not get to the Board of Pharmacy email that's in there. Mine was in, I found it in junk email a while back, just saying it was in spam. But it's now, I fixed that problem on our computer. So it's the more communication that you can get out, the better. But it's still, and getting this law passed that it grandfathers in like it should have been in the first place. But I mean, the conversations I have with doctors' offices, they're mad at me for making the phone call. I says, look, I'm just going through the motions, making sure you're going to get the license. My sister is a physician too. I haven't even brought this up with her yet because I would get an earful. So.
Are you aware that the medical board also sent the same letter out?
Yeah, I saw it. Yeah, I saw it was a medical board. I read stuff, but other pharmacists, they walk in, all they know is what the law says. So, but I appreciate you listening.
Yeah. But I think we all feel the pain, okay? Yeah. Yes, Danny?
So I want to start off by saying, CPHA, we support this motion that's on the table. We want to really thank the board staff. We think you did a great job in getting this information out in a timely fashion, considering the circumstances. We at CPHA took those messages, those alerts, and amplified it through our own membership. I also received calls, very scared calls from pharmacists. I received calls from physicians. I've received calls from security printers about what to do about this. And so, hopefully with the conversation that we're going to have about 149, I think we'll finally, put an end to this. I want to reiterate CPHA's commitment to helping amplify messages by the board. And Ann and I have had discussions about this, and I really want to commend Ann for this. And I think you did a great job with, given the situation that we were all kind of in. And so I want to say that publicly. And as I mentioned, CPHA supports this motion.
It's also my understanding that the forms are now available.
There's still a little bit of nuances that we are trying to work on, but I believe language in AB 149 will fix them, because I'm still receiving those calls on the security forms. But for the majority of prescriptions, yes, we do believe that those forms are now starting to become more available.
Steve Gray is a pharmacist and a pharmacy educator, and I get a lot of calls at the schools and students, and they go to work and they report the same thing that was reported here. I also believe that I don't know what else the board could have done. I mean, they sent out so many messages. They tried to get the message out there, but as said, some pharmacists are just paranoid. I don't know any other way to say it, and go from there. There are two other things that you need to be aware of, and I'm not sure, and maybe it's already resolved. Is 149 an urgency statute? Is that going, I don't remember whether that's an urgency statute or not, and whether it's going to go into effect before the end of the year.
I think we can talk about that more when we get to that
Okay.
item in the special meeting.
And then the second thing is, it's one thing to change the form, but people have to change their software too. And some of these software companies are outside of California, and they want to know, there's now been, as I understand it by the DOJ, a specified format that has to be involved for the serial number. Was that adopted, or does it need to be adopted as part of the regulation to specify that format? Because the companies want to know, okay, what's going to change, because the format then changes the software, and the software, even if it's developed, it takes time for each software company to get that, for the pharmacy to get it, for them to test it in their system and to update it. And I think all of this takes time. And one of the reasons I mention that is it's not just an issue with the printers. It's an issue on the other end as well. And so in the future, just keep that in mind also, because and some of the software companies are saying, hey, but the bill, I may not even be a printer. Because the bill says the DOJ might tell me I can't do, I want to even go through all of this effort and work to change it. So there's still a lot of confusion out there is only my point, but thank you.
Thank you, Steve.
Fred Mayer, representing California Alliance for Retired Americans. In the old days, us consumer and patients, when we went to the board, there was one specific person that we looked at who was a consumer advocate. His name was Ramon Casablanc. He was on the board. And Mr. Chairman, in the old days, you had a subcommittee for drug abuse. The recommendation I would like to make as a consumer advocate, is there a way that you can look at, or a future meeting, can you discuss the possibility of restating and going back to having a subcommittee on drug abuse? Marijuana is a major issue. Drug abuse is a major issue. Now that you have to call anywhere from 2 to 5 minutes to get the cures, and there are 5 different legislative issues, is there a way that us consumer people can focus in on a subcommittee that the board would have on drug abuse? And so I guess what I'm asking here, would you reconsider at another future board meeting re-putting in a person or a committee that just does drug abuse? Because I see Mr. Rule is here, the AG, and marijuana is not going to leave us with an $80 billion industry, and we've got lots and lots of consumer problems of drug abuse, and 4 of our people going to the hospital with overdoses. Thank you, sir.
Thank you, Fred. I think we need to confine our topic to the this bill right here, 1753. That will be another topic we could discuss in the future.
Mr. President, before Mr. Mayor sits down, I would contest your position that there was only one consumer advocate on this board. I would respond to you, sir, that we're all consumer advocates, And we're all here for the protection of the consumers of California. And to imply that there was only one advocate at this board table that had concerns for the consumer, I feel is insulting.
I apologize.
Thank you for your
I
apology.
eat crow, Stan.
Thank you for your apology.
I just want to say specifically that you had a subcommittee.
Thank you
so
for your
it wasn't,
apology.
I'm sorry. Yes, we had a subcommittee and the consumers had a place to go. We have no place to go now. It's very confusing for us. And again, if you don't want to listen to consumer advocates, that's fine with us.
Jennifer Snyder on behalf of the California Retailers Association and the National Association of Chain Drugstores. I just want to reiterate, this was what I would hope to be a fairly unique circumstance. We were in a situation with 1753 where all of us thought that there was language in the bill that allowed for a phased-in approach, and it was at the very last part of 2018 over the holiday that most everyone figured out that it wasn't. It was horrible timing. It was a horrible situation, and we hope that that doesn't happen again. A few things that I think have worked, that continue to work. I first want to commend the board staff on the amount of information that they provided. We took all of that information, shared that with our chain pharmacy members, and they disseminated that as well as they could to their management staff and their pharmacists. I think there has been some excellent communication between the staff and between us. I also want to make sure that it's important to note, and I know this will be talked about when we talk about the actual bill going through, but there is not only a problem with the prescription forms being available, but the content in the prescription forms is currently wrong. So the forms that folks are now getting that they consider to be the new right forms don't have compliant serialized numbers that are in compliance with NCPDP. Now, again, with the bill that we're going to be talking about in a few minutes, that bill actually allows for a phased-in period and will correct that problem. So I think within hopefully the next 2 weeks, we will be looking at solutions moving forward, and we won't have to be talking about concerns moving forward.
Well, this is also going to be a cost problem because I was at my physician's office, and he knows I'm on the board, so he says, look what I had to do. I just had to buy all these new forms after I just bought a whole bunch of other forms. So now he's bought the wrong forms again. So I wonder what's going to happen with that.
In the language that is, we'll talk about in AB 149, it does make sure that any form that is presented or the prescriber uses up until January 1st, 2021 will be a valid form. So that will allow for that time period for the phase-in for that. So.
Got it.
So Jennifer, so from the subscriber alert that you guys observed, you sent out your separate memo to all the employees within your organizations. So all the employee pharmacists should have read that.
I can't speak for each of my individual members. I just know that all of them were in constant communication with me and told me that they were disseminating all of the information that I provided to their pharmacists as well.
Yeah, well, thank you. I think this is very critical. Besides the subscriber alert that the board sent out, a lot of times some pharmacists may not be CPHA, CSHP members. Some of these could be just employee pharmacists. So I appreciate your effort in disseminating the information. I think you guys help us a lot on that part. Thank you.
Hey, Jennifer, I got a question for you. So it's the length of the serialized number that doesn't work in the NCPDP system.
Correct. The Department of Justice didn't consult either with the Board of Pharmacy or the pharmacists or our organizations, and so decided on a 15-digit serialized number. The NCPDP standard is a 12-digit serialized number. Yeah. Many unfortunate circumstances that have hopefully been corrected.
So the document that's coming out now is actually valid. It's just that if the pharmacy has to transmit that serialized number, there's a problem.
Correct.
Okay.
All right, so we'll move ahead with the motion to ratify the Enforcement Committee's recommendation, clarifying that the board will not consider this an enforcement priority until July 1, 2019.
Okay, so this is the committee recommendation. We don't need a second, right, Laura? Okay. All right, any further discussions from the board members or public? If not, all those in favor, please raise your right hand. Unanimous? Unanimous. Okay, recommendation passed.
Okay, great. And I also would like to commend the the board staff for the compliments they've gotten from the public and from the board members too. I know this was great effort. You tried to coordinate between 3 agencies and nobody was particularly cooperative. And so I think you all did a good job. So the board does appreciate all your efforts, definitely. Okay, onwards to AB 2138. Licensing boards, denial of application, revocation, or suspension of licensure, criminal conviction. AB 2138, effective July 1, 2020, places restrictions on the convictions, crimes, and other acts the board may consider when denying, revoking, or suspending a license. The law requires reporting on the board's website of denial summaries as well as a list of crimes that will be considered for denial and how they substantially relate to the qualifications, functions, or duties and the practice of pharmacy. As part of the discussion, members considered making a recommendation to board staff to begin working with the Office of the Attorney General and DCA Counsel to identify next steps, including possible statutory changes that would minimize the impacts of this measure as enacted. The committee was informed that this law makes several changes to the types of convictions that can be used as the basis for denial and allows the board to look into conduct that led to the convictions. It was clarified that only convictions within the past 7 years to be the most relevant types, and any convictions that have been dismissed pursuant to Penal Code Section 1203.4, in which the individual has successfully completed probation, may, by petition, be dismissed. DCA Counsel Laura Friedman informed the committee that her office is actively working on general guidelines for all boards. They are working on model language that will be consulting with the Department of Justice. As part of this public discussion, Mr. Gray noted that other healing art boards are also pursuing legislation. We were informed that the board that there are federal regulations that require the DEA to conduct a background check for any DEA registrant who has access to controlled medications. DEA law states that individuals with drug-related conviction may not be employed in positions with access to controlled substances. Additionally, federal law prohibits the employment of someone who fills Medicare or Medicaid prescriptions who are on the federal blacklist for associated with fraud-related crimes. So, is there any board comment on this? Public? Okay, there's a motion here to direct staff to begin working with the Office of the Attorney General and DCA Counsel to identify the next steps, including possible statutory changes that could minimize these impacts of this measure as enacted. Further, it is recommended that staff, in concert with Counsel, perform a gap analysis as the first steps towards implementation.
Okay, so this is a committee recommendation. Any other discussions from board members and the public?
Any comment from you, Laura?
If not, all those in favor, please raise your hand. Unanimous? Thank you. Motion carried.
Okay, AB 2859, safe storage products. AB 2859 requires community pharmacies that dispense schedules 2, 3, or 4 controlled substances to display a safe storage product on the premises. Pharmacies where a licensed pharmacist is the majority owner and a manager of no more than 4 pharmacies, these are exempt from the requirement. And these provisions will remain in effect until January 1, 2023. Interestingly enough, the language in this bill states that pharmacies are required to display these safe storage products, but does not specifically state that the pharmacy must offer them for sale. I'm not quite sure what to say about that. Okay. Okay. SB 212, solid waste, pharmaceutical and sharps waste stewardship. This establishes a statewide program to fund drug take-back and sharps disposal programs throughout California, effective before January 1, 2021. Cal Recycle is required to develop regulations guarding this stewardship program by that same date. Further, the board is required to review the stewardship for compliance with applicable federal and state laws governing drug take-back programs. As part of the discussion, the committee was informed that the board is required to review a list of covered and not covered products for sale in California. Implementation challenges were shared with the committee. For example, no real branders exist for basic responsibilities such as how the covered entities are to provide that information to the board. Board staff would prefer an electronic standardized format. However, there are no rules around that. So the board staff requested approval to develop regulations for the purpose of standardizing reporting to ensure consistency in the received data. As part of the public discussion, a speaker indicated that many of the provisions are still problematic. There's concerns with pharmacies that are included in the definition of covered entities. Additionally, it was highlighted that there's a requirement that 90 days after the effective date of the bill, January 1, 2019, covered entities will have to submit to the board all of the drugs that they distribute in California and annually thereafter. Any comment on this, Ann?
So we have a lot of responsibility here, but we're not the ultimate decision maker. It's Cal-Recycle, and they're actually having a workshop today. So we do have staff attending that, and after that workshop, hopefully we'll have some better understanding of the types of information and how they want it received, because in some respects we're just a pass-through organization, so we do need to partner with them. So we will be collaborating as they move forward with their rulemaking, and at the next committee meeting we'll hopefully have some tangible outcomes for the committee to discuss, specific at least to the data reporting requirements, because those take effect immediately.
It seems like we're being burdened with a task here that serves not much purpose for the board.
We have the opportunity to collaborate with a sister agency.
I hope we have more opportunities like this. Yeah, it's great. Okay.
Public comments.
Mo, any public comment on that? Okay. All right. SB 1109, Controlled Substances, Schedule II Drugs, Opioids. This requires completion of continuing education for prescribers on the hazards of opioid use. Further, this law requires that specific warning notice shall be prominently displayed on the label or container for an opioid dispensed to a patient for outpatient use. Excuse me. The CE requirement does not apply to pharmacists who prescribe under the collaborative agreement. As part of the committee discussion, the community members were asked to consider developing a similar requirement for pharmacists who prescribe under collaborative practice. Members agreed that pharmacists should receive similar CE. As part of the discussion, it was stated that it was not the author's intent to include pharmacists in this CE requirement. The author intended to regulate prescribers rather than pharmacists. President Law requested a sample of the required labels, and so I guess we'll look at those at the next committee meeting.
Actually, in the newsletter, we're going to do an article on this, and we'll put a sample of the label in there.
Okay, great. The committee recommendation is a motion to direct staff to develop a statutory proposal seeking CE requirement for a pharmacist operating under a collaborative practice agreement with the authority to work with the chair of the committee. The proposal will be brought to the board meeting on January 2019, and it is attachment 9 here, and it says effective 6 months of the effective date of the legislation. A pharmacist who, pursuant to any authority of this article, prescribes Schedule II controlled substance shall have completed an education course on the risks of addiction associated with Schedule II drug. A pharmacist who has completed such a course within the last 4 years shall be deemed to have satisfied this requirement. So that is the motion. Any board discussion?
Okay, so this is the committee recommendation.
Yes.
Any other board members, discussions, comments? Public? If not, all those in favor, please raise your hand. Unanimous? Okay, motion carried.
Before you go on the next one, I'd like to have a question. Maybe Ann or you could answer, or maybe the inspector could answer for me. We've been reviewing some of those disciplinary cases. I noticed that there's a decreased amount of diversion compared before. Am I wrong, or do you have any statistic since the inventory report, the shortage report? Do we notice any decrease of diversion or the large quantity? Before we have few 100,000 tablet loss, and lately I haven't noticed any of those large quantity. Is it the reporting is working, or the inspector notice any decrease of that? Is that effective? I mean, what we've been doing.
So with the regulation, I think that we'll be doing some post-implementation and looking at the data. I think anecdotally, we would believe that the sizes of the losses will continue to decrease because there'll be better controls, at least with the Schedule 2s, and the hope is that people look more closely at the other schedules as well. But this will be something that I would assume will be going back to the Enforcement Committee to assess the effectiveness of the regulation. It's a little bit early because we're still focusing on compliance and making sure that we're up and going, but we'll be able to look at the sizes of the losses and the number of losses that we receive. I think we would probably expect that we will be receiving more losses, but less in terms of quantities lost, because there'll be better controls, especially with the Schedule 2s.
Yeah, that's good. I don't know. On the reporting, they only report of the losses, but they do not report of pharmacy that order large quantity. So I would like, in the past, by the time we find out, it's way too late. It's been happened long time and very large quantity. I would like you guys put a little more attention on the pharmacy that order large quantity, pay a little more attention on them, so to preventing something happen. Because some of the pharmacy, when they do that, they make a kill. It pays for the crime. So what? You revoke the license. Hey, they already make their money. So I like to you guys pay a little more attention for those locations that order large quantity. Maybe certain quantity they have to report it, or you have to monitor a little closely.
Michael Ignacio, Supervising Inspector with the board. So kind of echoing what Ann was saying, that, it's still early in the implementation of the reconciliation report, but we've been focusing on the staff level on educating our licensees and pharmacists in reporting reconciliation kind of outliers to us. So it's still in that process right now.
But to address the policy concerns that you're stating, I believe that we can work with the chair of the committee and agendize this for a future item that will allow us to discuss in more detail. I thought you might.
I look forward to it.
Sang Laura's song.
Okay, thank you. And after that, we've got another motion here. Okay, and the motion is to approve the proposed statutory language for the Business and Professions Code of 4052.11, and to direct board staff to secure an author to sponsor the statutory change. And that's referring to the prescribing pharmacist education. So,
Okay.
board comment? Go ahead.
So this is the committee recommendation.
So I think that council would indicate that because the language was not available for the committee, it was follow-up action subsequent to, it may require a first and a second.
Clairvoyance.
We need a first.
Well,
Debbie?
you made the motion, right?
I made the motion.
All right,
So I'll
motion
second.
by Alan,
And I'll
second by Debbie. Any further discussion? If not, all those in favor, please raise your hand. Unanimous? Okay, motion carried.
All right, I'm on page 9 of 13. Here we go. Okay, SB 1254, hospital pharmacies, medication profile lists, profiles or lists for high-risk patients. This requires pharmacists at a hospital pharmacy to obtain an accurate medication profile or really an irritating noise, or list for each high-risk patient upon admission or discharge. The criteria for determining whether a patient is high risk will be established by each hospital. Additionally, the law allows for this function to be performed by a pharmacy technician or intern pharmacist if they have successfully completed training and proctoring by the pharmacy department. The law also allows for other healing arts licensee to do this adopted pursuant to Division 2. Under the provisions, the board has the authority to adopt the regulations. As part of the committee discussion, the committee members determined if field staff should identify hospitals that have chosen to implement this medication reconciliation under the purview of the pharmacy. The board staff explained that the committee data collected from hospitals could help with the development of policy moving forward. A member of the public stated that this is one of the most important bills of the year and encouraged the board to take the opportunity to make a very strong enforcement position on the implementation of this bill. Now for a motion regarding this, committee recommended to direct board staff to collect information on how hospitals are implementing the collection of data pursuant to SB 1254. And attachment 10 contains a copy for the language.
Any public comment?
Point of order. Consumer advocate Fred Mayer. I'm not going to jump up. I got a heart condition. But why is it an intern and why is it a pharmacy tech? And why isn't it a pharmacist who does this job? I'm concerned about a pharmacy tech. I'm concerned about an intern. I just don't understand. Can you explain that to me?
You know, I was just reading what it says, Fred, and maybe the way it was prefaced in here, it just says, notwithstanding any other law, a pharmacy technician or an intern pharmacist may perform the task of obtaining an accurate medication profile or list for a high-risk member if both of the following conditions are met. So I'm assuming that it's not that the technician or intern would evaluate the list, it's just that they would collect the information. Is that correct, Dr. Shad?
So if I may, the board was not the sponsor of this legislation, but the policy behind it was based on a study done by a hospital in Southern California. And that study demonstrated, one, the value and importance of an important medication safety list, but then also who appeared to be appropriately trained to collect that information. And I believe it was that study that served as the starting point for the legislative proposal.
You need to turn on the microphone. You need to turn on the microphone, yeah, so people can hear.
Fred Mayer, Pharmacist Planning Services. So I go in for a bypass quadruple surgery. I get released from surgery, Marin General Hospital. The outpatient person was a nurse practitioner who was used to giving out medication. The first medication she gave me was levothyroxine. I said, I just had bypass surgery. Why would I be on levothyroxine? She says, I don't know, but that's what the hospital's prescribed. The second medicine she gives me is called Zocor. And again, I can't remember, simvastatin. She says, I want you to take one of these every morning. I said, gee, I've been a community pharmacist for a long time, and we always used to say an hour after dinner because it interferes with the making of the cholesterol after you sleep, an hour after you sleep. So that was wrong. The third thing I said, she gave me another medicine that was going to kill me. To make a long story short, this was a nurse practitioner. To make a long, quick story, I said, I want to talk to the hospitalist. So I talked to the MD, and the MD says, well, she's got this wrong. The levothyroxine belongs to the guy in the next ward. The second thing, they told me that simvastatin's all wrong. You should be taking it at bedtime. And the third medicine that didn't even belong to me. So the point of order is, I don't understand why an intern, why is someone like a pharmacy tech doing this? I need a pharmacist. I'm a consumer advocate. We train you 4 years undergraduate, 4 years of graduate school, a year internship, and you are the experts on drugs. So what in the hell are you doing giving me somebody that doesn't know an intern? I'm a preceptor for, I've done my time, but I'm a preceptor for interns at Touro University, and they don't know borscht about drugs, I'm sorry to say. So give me somebody that's qualified, but don't send me somebody who's going to kill me with levothyroxine. Thank you, folks.
Sorry to bother you.
You know,
And
Fred-
again, I apologize for taking up too much time.
Dr. Mayor, we appreciate you coming. And that dance step was very impressive. Once again, the intern and the technician, it's when you arrive at the hospital, they're writing down the medications and then handing it to the pharmacist to evaluate. It's not that this law or that we're saying that the technician is counseling you.
But where is the pharmacist? I mean,
Well,
do they know
it's-
the difference? The nurse doesn't know the difference between levothyroxine and me with having bypass heart surgery, and they're going to put me on this drug that I never seen before.
But so this
all right,
isn't,
okay,
this isn't
I
at,
apologize.
this isn't at dispensing. This is, this study found is that it's very important to get a list of medications pre and post so that we can make sure that the patient doesn't go home and have duplicate medications at home. That's what this study found. And so once again, it's, the pharmacist can write down the medications on a piece of paper, or a specially trained intern or technician, and then the pharmacist will take that information and work with the patient after they're discharged.
I'm just a dumb pharmacist, and I'm now a consumer advocate. So I'm asking the question, maybe we got a shortage of pharmacists, but you folks are trained to do this on the intern, whether it be coming in the hospital or leaving the hospital. So where's your pharmacist? And again, I'm being harmed. And I'm just saying your job is to protect the consumers. Thank you. I've spoken enough, and I apologize to the entire board for being outspoken.
Well, I just was gonna say the same thing that Debbie was saying, and that the tech and the intern is actually taking information down. There's gonna be a consultation at the end, so you will have a pharmacist.
I don't think we have to justify this any further. Let's just move on here. Let's get going here.
Okay, I just want to remind everyone, we need to restrict our topic under discussion, particularly to this area here. I know there are other issues also about whether you should or should not somebody, that should be the early stage, should be the testifying in front of the author of the bill to justify that. So when this is signed into law, we're only discussing about implementation of the law.
Okay, so.
All right, so we have a committee recommendation here. Okay, well, motion by the committee. And any other board members comment? Public comment on this? If not, all those in favor, please raise your hand. Unanimous. Okay, so motion carry. And Mr. Chairman, can we take a 10 minutes break
I think it's a
before we
wonderful
go
idea.
on?
I think it's a wonderful idea.
Thank you. Let's take a 10 minutes break, okay? Okay. Ellen, are you ready? Already? Okay, we're back in session. Thank you. Please be seated. Ellen?
All right. Here we go for the non-controversial SB 1442, community pharmacy staffing. This bill prohibits community pharmacy from requiring pharmacists to work alone. It requires another employee of the pharmacy or establishment to be made available to assist the pharmacy at all times. Exceptions are detailed in the bill. As part of the committee discussion, staff was directed to work with council to research the DEA requirements to see if a background check would be required under the Code of Federal Regulations, or if the board should develop such a requirement. Staff will report back with a recommendation at the next meeting. Members of the public requested that the board clarified what it means to, quote, assist the pharmacist, end quote. An opinion of the intent was provided, which was to identify a staff member, not a pharmacy technician, within the establishment to relieve the pharmacist for a short period of time. In opposition, a different context of the intent was to provide an actual assistant to help the administrative duties. In addition, a member of the public stated that there may be staffing issues with separate ownerships between pharmacy and the retailer. An example that provided was a CVS pharmacy located within a Target retail store. No action was taken on this item. However, I imagine that there's probably some discussion that might be beneficial. Board members?
Yes, I'd like to comment on that.
Uh-huh.
I don't think your mic's on.
Okay, because the law is clear that, and it's 4113.5, and it says that a community pharmacy should not require pharmacists to engage in the practice of pharmacy at any time the pharmacy is open to the public, unless either another employee of the pharmacy or pharmacy is located within another establishment, and employment of that establishment in which the pharmacy is located is made available to assist the pharmacist at all times. It clearly says at all times, and I'm noticing as I travel and talk to pharmacists that they are not getting the help. And this law was passed January 1st of this year. And I actually talked to one pharmacist that said her company actually said that the law is too vague. And I don't see that it is vague. It says that there should be help. And just like Mr. Mayor was speaking about prescription errors and pharmacists working alone and having to stop and ring up groceries. There's a reason why this law was became a law. And I don't think that that confusion is there. So I think we need to do something to make sure that this is being enforced.
I'm not sure where to go with that, like a lot of things. Oh, there's some public comment. Let's go with that.
Well,
I
have a comment.
Okay.
I think our problem is we have to find out what the source of the problem. Why we have such a shortage of staffing in the pharmacy. The reason for that is the prescription, the reimbursement. The reimbursement is so low, they cannot afford to hire another employee. So I think we should. I mean, it's not in our jurisdiction to changing those reimbursement rate. But I think we should have a chance to look at the PBM, how they reimburse the pharmacy. I think those are the source of the problem. It's not the owner. I mean, the owner, if they have the business, they would hire enough help. And then if they cannot afford it, you cannot force them to hire extra people. So I think the main source is the reimbursement of the PBM. I think that's our problem.
Well, I don't see that this would be affecting pharmacy that you're talking about as far as, because it doesn't include the independent pharmacists. So I don't see that being an issue.
I'm encouraged to hear the board's comments on this particular issue. My name is Greg Gurm. I'm a licensed pharmacist for over 42 years. I'm also the president of the Independent Pharmacists Association. I'm speaking for myself and over 200 employee pharmacists.
Greg, could you put the microphone a little closer to your mouth? Yeah, okay, so people can hear you better. Yeah.
Okay. SB 1442 lists about 3 pages of pharmacist duties that are mandatory for them to complete. SB 1442 allows pharmacists to perform these duties. It's a win-win for the pharmacist and the consumer. Leaders of the large chain pharmacies know and understand the law. Unfortunately, they're implementing the law by allowing somebody in a huge store to be designated as the help for the pharmacist when they need to be called. I feel strongly that this does not fit the intent of the law. Leaving the pharmacist alone, or not leaving the pharmacist alone, is the intent of the law. I asked the board, and I've heard from the comments that, I'd like to hear a clarification of how the board feels this law should be implemented. At this point, I had some introductory comments, and I'm going to defer the rest of my time to Mark Rouse, my colleague.
Mark Rouse, you've already heard from me. I'm the treasurer of the Independent Pharmacists Association, which is the 200 members that work at the Raley's stores. And we've heard from I've talked to other pharmacies too, asking them what's going on and also seen what's going on in our chain. We are not seeing a designated tech or clerk available to a pharmacist during these certain periods of time at various stores. We're looking for clarification. Is it okay for, if a board inspector walks in, we just need board inspectors to come in and make these decisions and say, this is good or this is not good. Does it follow the law? And what happens right now is you're working as a single shift and you call for service, and the person may or may not come in. It could be any employee. The law says an employee, means a certain designated person. Plus, is that person HIPAA certified? Could that person get on the computer? Can that person even assist a customer, let alone ring up? Maybe they can ring up a prescription. So the law, I believe, was intended, and I've been in contact with Senator Stone's office. He's a pharmacist, and he was a co-sponsor too, was intended to make sure that when you are working, you will have a tech or clerk work with you, do that in that store, and that is there to protect the public and protect the pharmacy. Yeah, it's a cost issue. We get it. And what we're hearing is, well, our labor budgets don't cover it. Well, our labor budgets have to cover compliance with the law. So if this is the new law and it serves the public and serves the public interest, then this is helpful. Because right now, a pharmacist works alone at a typical slow store, and they are by themselves, and they got to go to the bathroom. There's no one there at the counter. It's a drug diversion issue. Anybody can hop the counter, whoosh, grab your Norco, grab whatever's on the shelf, they're gone. And they take off with it. I can show you YouTube videos if you want to see them. So, you got to sit down and eat, you got to do something, but the idea is to have someone there at all times at the pharmacy counter, make sure it's manned. And it's a patient safety issue. So we are here to ask the board to make a ruling and to stick with it, hopefully to be the intent of the law, which is to have a pharmacist assisted at all times, not just someone in the camera department or in the makeup department or whatever that you can call in. Eventually, if they get out of a check stand, they can come back there. But I've talked to CVS, I've talked to Walgreens, various people working there, and they said this is not being implemented as they expect it to be implemented and what they understood from the way the law was going to be implemented.
Yeah, I want to add something to this. It came up at LegReg this morning. The UFCW is going to be filing a petition to request the board to promulgate regulations on this. And they're going to be meeting with the board and providing draft language as well. So this is going to be an ongoing thing. So just wanted to let you know.
Well, the question for the board is, what do we do tomorrow and the next day when I go to work? I mean, because if you're a pharmacist in charge, by law, the law says you need to have put some on your schedule, and you get put in a bad point, a bad spot. Your boss says, no, I'm not going to let you do that. And there's also a law in the book says it's a misdemeanor to interfere with a pharmacist in charge putting out their duties and following the board law. It just, once again, it puts us in a bad spot, and we need clarification as soon as possible. And there's a lot of I've had pharmacists that have contacted me through the union saying, I will not work a store if I'm by myself. So they find somebody who's desperate enough, and they'll do it. And they'll work by the store and do an 8-hour shift with no help and back in the pharmacy. Other than maybe you can call somebody out of a check stand up front when they're done, and they'll come and help you.
Well, we'll do our best to get the advice as soon as possible.
Okay. Thank you for listening.
Thank you for your time.
Well, if the law specifies that the pharmacist is not to be at he or her by herself at all times, that's what it states, though. And if they don't follow, that's the totally violation of the law. We'll leave it up to the interim executive officer to handle that.
My name is Scott McIntosh. I'm a pharmacist in I've been a registered pharmacist in California for over 32 years, and I'm here to represent myself. I just kind of wanted to express a couple of circumstances I've had this month since SB 1442 started on January 1st, and I'm hoping that the Board of Pharmacy will enforce SB 1442. On January 3rd, I worked by myself from 6 p.m. to 9 p.m. in the pharmacy. I called for assistance in the pharmacy 3 times from 7:30 p.m. to 7:49 p.m. Nobody came to the pharmacy or called the pharmacy to let me know that nobody could assist with patient care for our consumers. At the end of the shift at 9 p.m., the manager let me know that she couldn't assist me in the pharmacy because she wasn't trained to work in the pharmacy. So there's another circumstance on January 24th. I worked a graveyard shift from 10 p.m. to 8 a.m. I called for assistance in the pharmacy for patient care for our consumers at 6:58 a.m. The manager called me to let me know there was no one available to assist in the pharmacy until 8 a.m. So I hope that the Board of Pharmacy will be enforcing Senate Bill 1442 going forward.
Go ahead, Fred.
Fred Mayer. I'm so pleased with this bill, and I thank the board for looking at it. I'd like to use my time here to say, as a consumer advocate, we would like to see certified pharmacy techs in every pharmacy, not leaving the pharmacist alone. Prescription errors are increased according to the Food and Drug, according to the World Health Organization, according to what I read, according to what your own Board of Pharmacy sends me for my students to do, which are cite and fines, wrong pill, wrong bottle, wrong drug to the wrong person, etc., etc. As a graduate UCSF, I was very, very pleased to see that we went from counting, pouring, and typing in my day, 1954, to clinical pharmacy. So the point that I'd like to make as a consumer advocate, let's use this instead of counting, pouring, typing to be out front. But the problem comes under Senate Bill 493, that consumers, we are so pleased to see that pharmacists are doing more as part of the team of physicians, nurses, and with the shortage of doctors, we need to do more, especially in light of the fact that we have more and more seniors living longer and longer. With drug interactions, review of patient profiles, over 90 laws, consultation on drug information, immunization, smoking cessation training, dispensing of birth control pills and emerging contraceptive, travel meds, diabetes, hepatitis screening now going on. The pharmacist can't be in 3 places at once. In my local Safeway, I went in to talk to the local Safeway person in San Rafael, Marin County, where I live. He says, Fred, when I give immunizations and I'm required by Safeway to do 30 a week, I have to close the pharmacy because I don't have anybody in there. When I come back, there's 10 to 12 people lined up waiting for their prescription. So the stress and the pressure on the pharmacist is immensely. And again, as a consumer advocate, I don't care about your budget. I don't care about how you're going to pay for it. Your job, for me, is to take care of the patients and the consumer and the safety of our patients. And it's not a money thing to me. It's saving lives, keeping out of hospitals, emergency rooms, and doctor visits by the pharmacists being trained for what they're doing. So pharmacists need a full-time pharmacy tech, and we don't want to settle for anything else than a pharmacy tech or somebody that's trained. We're not dealing here in popcorn, folks, where you take one bottle and the pill and you dump it into another bottle or popcorn. We're serving pills here that kill people. And again, I need to remind you, time's up. Shall I leave? Thank you, sir. Let me just finish with a big, big closing. 42% of all flu vaccine last year, according to CDC, was given by pharmacists. So they can't be given flu shots in a little private room, according to HIPAA. Do the cures programs, do the programs, and then I come in and want some consultation as a consumer in the cough service department. I need a cough for my inspector and OTC. He can't be out front and somebody watching the back because DEA says to our consumer group, we're not going to allow it because they're stealing your drugs. So again, what I'm asking for here, folks, is a trained pharmacy tech, not a high school kid or somebody that they're going to call out from the Apple department in the grocery store. Thank you.
Thank you for your comment.
And I apologize if I embarrassed any of you folks.
All right, come on up.
Jennifer Snyder on behalf of the California Retailers Association and the National Association of Chain Drug Stores. I want to just spend a first minute trying to further clarify at least what we believe the intent of SB 1442 was. Our organizations ended up taking a neutral position on that bill, and to some extent we agreed with what we considered with the intent, the ultimate outcome of that bill. The language that's included in SB 1442, if you don't mind, I'd like to read that paragraph just one more time for folks to hear. It says, a community pharmacy shall not require a pharmacist employee to engage in the practice of pharmacy at any time the pharmacy is open to the public unless either another employee of the pharmacy or, if the pharmacy is located within another establishment, an employee of this establishment within which the pharmacy is located is made available to assist the pharmacist at all times. We worked with the author of the bill. We also expressed concerns originally with both the Assembly Business and Professions Committee and the author that we wanted to make sure that it didn't have to be somebody that was within the pharmacy at all times, but that somebody would be available who was cross-trained, who would have the ability to come assist that pharmacist whenever they needed. That is exactly what we consider the intent to be. Disappointed to hear that UFCW is interested in having the board take action on a regulatory front. I think if there is concerns about whether or not the intent of the bill is one way or the other, we probably need to go back to the legislature and talk to them about it. Again, our organizations wanted to take, our intent is to take a neutral position. I think I would also caution the board, the effective date of the bill was January 1st. It's now January 29th, 30th, what's the date today? It takes organizations a period of time to adjust to new rules and requirements. Some of our organizations more that are in grocery that have a smaller volume within their pharmacies, they are probably more of those entities that don't always have somebody right there with the pharmacist at all times. So it does take time for folks to actually implement the new requirements. So I would caution the board to take action.
Was it your understanding that the person that would be there to assist was to assist the pharmacist in the non-pharmacy functions that they're called upon to do, or that they're supposed to be there to assist in the pharmacy function? Because, I mean, how do you just take anybody and cross-train them to do what a pharmacist can do?
Correct. No, it would be non-pharmacy functions. It was,
right.
Yes.
In a large pharmacy where they have to handle over-the-counter stuff and whatever. It was for the purpose of doing that.
That's what we believe the intent to be.
Okay, that's what I thought.
So just to finish, I think we have been actively in providing information to our members on the bill and encouraging them to address, what we consider to be the intent. I would also maybe recommend to the board it'd be important to make sure that pharmacists and pharmacy chains are well aware of the new requirement, to make sure that they know that the requirement's in place. I think that's first and foremost, just to make sure the information is out there. And I know maybe the board has included some of that information in possibly some newsletters in the past, but I would encourage that to be the first action, and then allow for folks a little bit of time to actually be able to implement the new requirements.
Hello, my name is David Fluitt. I'm Director of Pharmacy for Raley's, sometimes known as Mark Rouse's boss. A lot has been said here, and I think that I still can lend A perspective here from management, I take this very seriously. I think anyone in my position would in management, that we consider patient safety to be our highest priority. When this bill came out, it caused a lot of scrambling, some to the extent of its ambiguity, but also to really determine what its intent was and really how we went about this responsibly to make sure that this was carried out to the degree that it needed to be in the name of public safety. To maybe piggyback upon your question, and that is, do we allow assistance in the pharmacy? And we do, but we went through an extensive process of finding out what pharmacies were exposed. We took a look at what their prescription volume was. We looked at some of the unique parameters that prevented coverage for an extended period of time, which led us to conversations and a problem-solving process there as well. But we also take a look at what it takes to cross-train people effectively into those roles where they will be taking intakes, so that if someone can't get an immunization right away, that the person who's coming to the assistance of the pharmacy can articulate that correctly to the consumer. All these take time and resources in terms of training and education, developing protocols and things of that nature. So ultimately what I'm asking for is that it takes us some time to get from the point that this law takes us to the point where I think the intent lies. And from a management perspective, we're doing everything that we can to make that happen. But as Jennifer says, it just takes some time and it takes resources. So I would ask for or urge enforcement discretion in this as we take a look at exactly how it's affecting and how it's being brought about collectively by these organizations. Thank you.
Come on up.
Jazzy Graywell with UFCW. So I just want to clarify that we are going to initiate a promulgation of regulations. However, that's to get clarity, specificity, and consistency so that the board is able to enforce this bill and that our partner stores are able to implement it in a consistent manner. So the intent, we're not out there to change the intent of the bill. We just want to make sure that it is implemented and enforceable across all stores and across the state.
How do you go about that?
Promulgating regulations?
Yeah.
So we'll have a petition for rulemaking. And so once we submit that, the board has 30 days to either deny the petition or put it on a next agenda hearing. And then the board can accept the petition in whole, deny the petition in whole, accept part, or deny in part. And so the idea is that in a collaborative process that we're able to come up with regulations so that we can be able to implement this bill effectively.
What type of staff is your organization suggesting be available to the pharmacy as you go forward with your regulatory process?
Any ancillary staff.
By any ancillary, I realize you're not referring to somebody selling apples and avocados, but what are you referring to by ancillary staff?
Well, we internally haven't vetted the language in terms of what ancillary means. Right now, that's up to the discretion of the employers to identify a staff person. We've been getting notices of employers doing things very differently. And so that's something that we're taking into consideration and to help define what that ancillary staff person would look like. We also want to leave it flexible so that the employer is able to have someone on staff that can be that ancillary person.
So we're talking about Raley's, let's say, and they have a pharmacy and they also have ancillary staff. So your bill would suggest that anybody who's been somewhat cross-trained for the pharmacy can be used in the pharmacy when needed. Is that correct?
Correct.
So I guess then to your point.
No, I realize not for filling prescriptions.
To your point, Stan, then you kind of said, the apples and bananas person, but if the apples and bananas produce person was trained like this gentleman maybe suggested, that would be acceptable.
So it would be someone who is able to perform the clerical duties and non-licensed duties that the pharmacy would require. Correct.
It could be a grocery bagger. It could be a grocery bagger. It could be someone who's, the butcher, correct?
Yeah.
As long as they're trained.
As long as they're trained to be able
So
to
it could be
perform the
anyone within
clerical
an
duties.
organization as long as they're trained is what you're getting at.
So isn't that what it is now?
Well, I mean, it sounds like that's
No,
what,
no,
that's,
it's not.
it sounds like that's where, I mean, we just only had one stakeholder testify, but it seems like, or maybe Jennifer too, but it seems like that's where they're going, but they aren't there yet. So what are your thoughts on, there's a transition time?
On what to be doing in the transition?
Right, I mean, do you agree that there's just a transition time and perhaps we need to, before we knee-jerk and do something, maybe we need to let the process kind of take place, get training in place, and see if it isn't okay?
I'd like to say something about that.
I want her to answer. I don't,
Okay.
I'm sorry. I want, she's UFCW, your board, and, I mean, you need to be a board member, not a UFCW member.
So my union has not taken a position on that process. However, the bill was passed and signed in law at the end of last year. So there was a time period in which employers knew that this bill was going to be implemented January 1st. And so from what I've heard from our pharmacist members is that they've been needing this help for the past few years. And so now that this bill has been implemented, they were expecting a implemented strategy to have occurred from when the bill passed to the beginning of the year. And so our pharmacists are working alone, working 8 hours, requesting help 3-4 times during the day, and they're not getting the assistance that they need. And so this comes down to consumer protection.
Okay, so you say 8 hours, so the whole shift they're working by themselves?
Some pharmacists, yes. Some pharmacists report working 4 to 6 hours alone.
So what you're looking for is a statement of steps to initiate this program, or it's hard to enforce. I mean, there's Michael will have to pop in at 6 in the morning to make sure there's somebody there. But in a certain way, I appreciate the help. Okay, but I think we're all looking for something substantive that you're looking for, and just these terms to enforce. I mean, it's irritating that it's not being enforced. Okay, I agree with that. People are just ignoring the law, and that shouldn't be. But nonetheless, it's somewhat like consultation. It's tough to enforce, and so we want to make sure it's specific and something that we can do, and something that's amenable to real regulation.
They are going to work together with us. We already talked to her. They're going to work
Oh,
together
okay,
with us
okay.
in developing the language and so on and so forth. So.
Oh, okay, good.
So what I've heard described is that this organization would like to petition the board, and that means that they will be submitting language.
Mm-hmm.
Here's our proposal. What does the board think? Would you like to act? In that context, yes, then the board will decide whether or not it's ready, ripe, appropriate to proceed based on that proposal, or it would like to take its own action.
I think it's important for all of us to realize that that little happens immediately. And we just saw with this bill about the printers and the serializing of the prescription blanks for controlled substances, that there was the expectation that bang, the first of the year, this is how it would be. And the board encouraged the author that you need a phase-in time, even if it's just a printed blank with a serial number. You need a phase-in time. And I just would, suggest the same with almost everything that's new or different or higher expectations, that you do need a phase-in time. You might suggest, well, the phase-in time should have started in September because this bill was going to be signed in December. Well, but you do need a phase-in time, and I think it's unrealistic to expect, at least from if history proves itself to be correct. It's unrealistic to expect something to be effective on the 1st and then to expect it to be totally done on the 1st or the 2nd. I mean, we all see needs for phase-in. And perhaps, I mean, we're only not even a month through with January. And I just, would hope that patience and cool heads would prevail here and give the bill a little time. Granted, there are going to be people who drag their feet, and there are going to be those who don't want to do things that are expected of them. But generally speaking, we ought to allow some wiggle room where there's a phase-in period.
I have a question, and I see that there's some research that's being done to see if there's some DEA requirement. Did you guys get anything back on that?
So at the committee level, we were going to be looking to see what the DEA requirements are in terms of background checks for people that have access to the controlled substances, and that will be reported back to the committee.
Stan, the other thing is that what they're proposing is regulation. And from history, regulation isn't going to happen overnight either.
Yeah.
By the time the regulation's done, the
The
phase-in
situation
should
could be
be
fixed.
there, right?
So,
Thank you, Greg. That's what I was going to say, is that the regulatory process does take a little while, and so there will be, from the moment the petition is submitted, there is a 30-day window then too, and then the petition actually has to be adopted and gone through review. So that is a time period as well, so employers can adjust, as well as we go through the petition process to ensure that there is clarity.
thank you.
Can I say something? I'm sorry. Who am I?
No, you go
who's-
ahead.
Just as a sort of process or procedure question, it's not clear to me that this situation would be substantially improved by regulation. It seems to me like the issue is really a compliance issue and a sort of application of the law issue. I mean, I don't know. I guess the board could define what ancillary means or whatever, but I don't know that that's going to necessarily increase the level of compliance. So, but that's neither here nor there. That's just sort of what I'm hearing and what my response is to it.
Yeah, and that's why my question is, I mean, when you say someone available, even if you say someone available there, I don't see why that should be so difficult to have someone else in the store that can ring a customer.
Right. So like that goes to my point. I mean, there are terms in the statute. You could further define those terms, but arguably those terms are enforceable already. They're not so vague that they're not enforceable. So whether regulation is necessary and would meet OAL standards for necessity, I don't know in this circumstance.
The only thing is, Josh, that sometimes if something is not considered to be well clarified, that's a reason for not complying. So if they have something that's clarified, I mean, it may even be to clarify what training means.
Right.
Cross-training.
The only counterpoint to that is if someone is disinclined to comply, then the pendency of regulations would be another reason to wait for those before complying.
Touche.
Yeah. Yeah, I mean, I don't want us to over-regulate this, and I think just even from what we've heard, the expectation of maybe what that person would do could be different and might depend on the business model. I don't know. Because, I mean, Cheryl, you said possibly all they would do is just kind of be able to ring up somebody.
I've gone to stores and talked to pharmacists since January 1. And I've gone to some chains, actually, when I went to CVS, they pretty much had somebody all the time. But I've gone to others where it was said that, well, it's not clear. I said, well, do you have someone available? And if they have someone available to ring up the register, that's why I'm asking Ann about the DEA requirements. Because I don't see where that should be so difficult to have someone ring up items, OTC items, where the pharmacist is on the phone and a customer's just ringing up or just picking up, let's say, a refill. And
So you're
there's
not
no
even
consultation.
your expectation isn't even that they'd be a clerk. It's very minimal type of job duties.
To help the pharmacists when they're back there by themselves.
Okay, thank you. Thank you. Okay, I don't think we're going to solve anything right now. Go ahead.
Oh,
one more person? No.
Oh, one more comment. All right, come on up.
Thank you very much. Tim James, California Grocers Association. Really appreciate the opportunity to be in front of you today discussing this issue. I think there's just been a really great conversation. I don't want to repeat some of the comments from the Retailers Association and from Raley's on what they're working at, but let me see what I can add to this. And when you look at least from the grocery perspective, how we deal with many other regulations that we have on the sale, the health and safety regulations we have on the sale of products. We have in a number of different areas already set up systems where we can cross-train employees. You have to be a certain age to be able to sell tobacco products. So we need to make sure we have folks that, match that up. On the food safety side, there are certain individuals that need to have proper training to make sure that, hot food's hot and cold food's cold. Nobody's getting an illness in the process. We have cross-training between departments for that. And really, I think on the implementation of this is what we're looking at doing is that level of cross-training to make sure that there is that support system within the store like we've seen on other health and safety regulations. So we'll commit to you all to keep in touch with how our industry's implementing this ordinance. We do appreciate some of the comments that were mentioned in regards to compliance, not only in regards to the timing and the ability to get this up and running. This is, kind of a first time thing. And, we recognize as well, the board even, it appears the board even has some questions on what some of those employees that we do cross-train, what sort of technical skills and training they may need to be able to properly fulfill that. So we're committed to that process. We're committed to the board to continue to work through that. We hope we don't get sidelined by any other processes that may cause a pause in gaining clarity. So we'll make that commitment to you, and thank you for the time.
Well articulated. Thank you.
All right. Thank you.
I do have a question on the subject. We were talking about auxiliary employees being able to come behind the pharmacy counter, but it's my understanding that pharmacists and pharmacist tech all go through criminal background checks in order to be behind that counter. And so the suggestion to bring someone back who's a butcher or grocer or checker, all great professions, but I don't believe they're required to have criminal background checks to be able to perform the duty in which the individual spoke about earlier. And so before we come to conclusions, we need to really take a step back and look at what a cause and effect we're doing.
Hey, Steve.
Yeah. Steve Gray is a pharmacist. I think that there's several questions. I think the one that was just expressed is of concern about the, checking the people that are back there. And it's not just behind the counter. Remember, they're out there, if they're just even acting as a cashier, they're selling prescriptions. They're in the will call area where there are narcotics there. And the pharmacist is back in the back taking care of something. I mean, it's not just available in the stock area and so forth. But there's another fundamental question, I think, in the language, which is causing confusion. The language started out saying that whenever a pharmacist is on duty, there had to be another pharmacy employee to help the pharmacist. And then the language is saying, well, could you, if it's in a facility where there's other things going on besides a pharmacy, could you have another person who's not a pharmacy employee there to help the pharmacist? That was the essence of it. And so it says it's available at all times. Now, does that mean they're available all times in the produce department and they're going to come over when called? Or does it mean they're available in the pharmacy to help the pharmacist at all times? There's two ways to look at that language. And I think the clear intent following this from the public hearings on through to implementation was that there is someone in that pharmacy to help the pharmacist at all times. That's the way, the language. But there's confusion about that. So rather than have hearsay, I suggest, for an example, if you want to wait for a regulation, which I don't think should be done, I think it was intended to be implementable January 1 by statute. Regulation's going to take, what now, a year or two to go through? I don't know if it's a petition, whether that makes a way to shorten it. But if you really want to know what the intent was, let's get Senator Stone here. You know, he signed on to the bill. It was his. He supported. He knew what he was going to. Let him come here and tell you what his intent was as a pharmacist, someone who's out there hearing from pharmacists. Pharmacists can walk into his office at any time in Sacramento or down in Temecula area and tell them the problems they're having. Let's listen to him. And I can tell you there's something that you may not realize, having been responsible for 24 7-day-a-week, 365-day-a-week pharmacies. Pharmacists that are working alone are working in some of the most difficult times. These are not regular business hours where there's a lot of activity. They're working and taking care of urgent care patients after hours who couldn't see their regular doctor, but it's so urgent they need help right now. They're working in Sundays and holidays when PBM offices aren't open and they can't get insurance questions and they have to call doctors and get alternatives. These are very serious times when pharmacists are working alone and they are overwhelmed and they need help. That's all they're saying. And I believe the intent is for that someone, yes, it can be an employee of the supermarket, but they need to be helping that pharmacist at all times, not saying, I'll get there when I can. Excuse me, I can't consult your patient because I'm talking to the doctor over here, but when the guy comes over here from the produce department, I'll be able to come and talk to you. And that might be 20 minutes. Can you wait 20 minutes, ma'am? You know, you've just been to the emergency room with your child. Can you wait 20 or 30 minutes for someone to come over and tell you how this medicine should be used for the child? That's the kind of things that they're running into. They got to make decisions like that. Or just to answer the phone for someone to say, is my prescription ready? You know, people may not fill a lot of prescriptions after hours, but they pick up a lot of prescriptions after hours. And so you can't go by the data on when the prescription was filled. And so I think there's an urgency to this, and I don't think it should wait for a regulation. Thank you.
So, with that, back to my, comments. I think we know what the intention of this, or what this law was all about. But it's up to the Board of Pharmacy to interpret that and to implement it, right? And create rules around it. My challenge I'm still having is, if you're going to have anyone who is not a pharmacist, a pharmacist tech, or someone who's licensed, who hasn't gone through a background check behind a counter, are we causing more harm than good? If someone has access to, drugs, Schedule I drugs, and they can take it in, diversion's a big issue in this, profession, are we doing more harm than good? And our job, number one, is to protect the consumer. And so how we go about that, we need to be very thoughtful in our position. And I agree with Mr. Gray, let's not wait for rules and to be promulgated, because that process could be 12, 18 months, at best. And so we'll need to make some decisions, early on in the process. Thank you.
Hi,
Go
I just
ahead.
have a quick comment. My name is Steve Soon. I've been a pharmacist over 30 years as an employee. I think in regards to this issue, my only comment is that pharmacy has evolved quite a bit during the last 30 years, and it's much more specialized than ever before. And I think it may be disingenuous for someone to think that you can take someone who's working at another department and just throw them into the pharmacy department and have them be effective in providing help to the pharmacists. Back when I started back in the 80s, ringing up a prescription was pretty straightforward. We still had a typewriter. There was no computers yet. So when you sold a prescription, it was pretty much, okay, here's your bottle. How much was the cost? And a lot of times the cost was printed down on a piece of paper. There was any insurance involved. We had a manual form, like a credit card slip, where you ran the patient's insurance card on there, and then you sign it and you submit it for reimbursement. None of that is around anymore. Nowadays, of course, everything's by computer. And if you put someone in the pharmacy department who has never been trained there, or if you train them but they haven't been working there on a regular basis, they're not going to remember what to do. As simple as selling prescription, it's not about, oh, get the bag and sell it. You have to know all the proper steps about selling that prescription. Make sure you get the signature. Make sure you understand what's required in regards to consultations and also in regards to documentation for insurance purposes. And of course, these make sure you have the right medication for that patient and you're not selling someone else's medication to that patient that's showing up. Second thing is, if you're offering help to the pharmacist, someone presents you a prescription, it's no longer saying, oh, yeah, let me take the prescription and give it to the pharmacist and then you type it up. Again, you have to get a lot of information about that patient. Information about the patient specifically, also their insurance. And if that person is not able to do that, that is really of no help to the pharmacist too. Insurance are a very complex things nowadays, right? I'm sure all you're aware, there's literally hundreds of different insurance plans out there. And you can't process a claim until you've put that information in the computer database correctly. And if you have just one thing wrong, you get a reject. And unfortunately, the rejects sometimes don't indicate exactly why it's being rejected. I had one reject come back saying invalid birth date, when in fact it had nothing to do with the patient's birthday being wrong, but the insurance company came up with that nonsensical explanation. It just happened to be the wrong group number that was put in. So having the intent of providing help to the pharmacist, it only works if that person really is knowledgeable about what they need to do in the pharmacy department itself. And so it goes back again to proper training, but they have to be ready, available to do this at all times. Okay, thank you.
All right, thank you for your comment. Any other public comment? If not, I do have a comment. I want to specifically speak to Mark's boss, the gentleman, and the other owners of pharmacies. I understand your economic concern, but you're talking about pharmacists. Pharmacists are trained professionals who went to school for 8 years. Now, it's just unimaginable that you will leave somebody who has such a long training to work by him or by herself. I mean, this is all the way back in 40 years ago when the pharmacists came in and asked for ancillary help. That's how we create a category of pharmacy technician, is to help the pharmacist in order to promote the business and also the profession. And the most importantly is to increase consumer protection, reduce prescription errors, and the main thing is consumer satisfaction. Now, can you imagine if you see a pharmacist running by him or herself, or by herself or him or herself, even as a consumer, do you think you would get good customer satisfaction knowing that the person cannot cater to your need because they are too busy, right? So, and now we're at the stage 40 years later when people are asking for even increasing the technician ratios. And it's so unimaginable that now we're back to the old days. Instead, we want to just leave the pharmacist by that person, by him or by herself. And understanding that when you train a personnel in a pharmacy, there are a lot more things to do than just filling prescription. Do you understand that we have mandate, compliance, audits, a lot of things that you could do? And if one of these things you're not compliant, you know there could be heavy consequences after that. So by even sometimes paying one technician, even a technician, if it costs you whatever amount of money, the 8-hour shift, the kind of things that that person could do for the pharmacy could more than compensate for the money that you invested in. I mean, that's just my thinking. I hope you guys could think about it and consider that. And rather than having even the board chase after you to see if you are compliant to increase your customer satisfaction.
I appreciate what you're saying, and it resonates with my line of thinking as well. It predominates my thought process through this. When I go to the board and it says, I need some time to do this correctly. I think that's the reason I'm here today, because just to the previous testimony, a conversation about a patient's medications just to pick up can be complicated. And it is an opportunity. It is our greatest opportunity for customer safety. So we don't treat this lightly, but we want to do it correctly as well. And so when I sit in front of the board, I do ask for that sort of discretion on how we get to that point. We're not trying to just sort of fix this and comply. We're trying to create a process where we are able to do a very complex job with the people around us that can help us the most.
Okay, great.
Just as a point of
Thank
clarity.
you. We'll always will help the profession to try the better job, okay?
Thank you.
All right, thank you.
Thank you. Okay, where are we here? We've had about a half-hour discussion on this. We've had pleas for enforcement. Almost everybody is in favor of the law. The steps to enforcement are kind of complicated, and the initiation of the law is going to take some time. So anyway, I suppose the best thing to do is to discuss this at further meetings, keep track of it, and making sure that we're moving forward. And I'm not sure how to do that, but
And you could also get the clarification for Senator Stone for the main purpose behind that the bill, which is the most essence. That way, there's no misunderstanding of what not what is.
well, one of the things I'm kind of concerned about here is this is said by Senator Wiener here. Wiener and Stone. And as a matter of fact, I don't think it matters what their intent was, because we've got a law.
Well,
their intent has not much bearing on it.
I refrain from saying so, but there's case law clearly saying that individual legislators' statements of intent after the fact have no bearing on the interpretation of the law.
Thanks for validating me.
You know, I think kind of what we want to happen is for it to go back to enforcement, and maybe not back to enforcement, but and stay with enforcement, and have you guys kind of follow it maybe to the next board meeting and tell us, you know, we'll give groups time to see if they can implement programs, find best practices, hear from employee pharmacists, you know, what's working, what's not, and then bring it back to us at our next board meeting. And let's just see, you know, with time and effort, you know, what's happened.
Yeah, and just to confirm, this is Laura, sorry. I think that's actually what the committee planned to do already. It's already, according to the committee report, it was going to come back to the committee for further work.
So, to be continued. More to follow.
Yeah, because I mean, even like this DEA question, there's...
Okay, onward to chartered bills relating to the healthcare coverage, prescription drugs. There are three bills, AB 2863, AB 315, and Senate Bill 1021, that are intended to ensure that patients do not pay more for a drug if they have a health insurance than if they had paid for the direct cash price. As part of the public discussion, representative of the California Retailers Association and the National Association of Chain Drug Stores requested that the board delay enforcement provisions, which requires a pharmacy to submit a claim, but noted that submission of the claim is a problem because the systems do not allow for a submission. Counsel Laura Friedman recommended allowing staff and counsel more time to review each piece of legislation and the individual impacts. The committee agreed with the recommendation and asked the council to bring any recommendations to the January board meeting. January board meeting.
Here we are,
Okay.
right? So I looked a little bit more closely at these bills, and based on my review, I think what you have is that you've got the two new sections, new section 4079 and 4079.5, both of which do require the pharmacy to give notice to the customer at the point of sale for a covered prescription that what the retail price is, and that to the retail price if that's lower than the applicable cost sharing provision. And then it requires the pharmacy to, as you indicated in the report, submit a claim to the healthcare plan for that retail price paid in the same manner as if the claim was being paid through the plan or the insurer. And I think you heard the practical concerns about that. However, both, and those are, by the way, those provisions are both in AB 2863 as well as AB 315. They're fairly redundant in that regard. And both sections contain a subdivision, and it happens to be subdivision F in both of them, that explicitly states that the violation of the provision is not grounds for disciplinary action or for criminal action. Which suggests that there's really nothing for the board staff to investigate. This is not going to be an enforcement issue for the board. I mean, the law explicitly prohibits that. So I think from an implementation standpoint, the board staff could, certainly offer licensee education, or the board could do that through like script articles, something like that. Of the new provisions that they exist. It could also look to whether or not amending its notice to consumer, it has some value, something like that. Basically focusing on education either to the pharmacists or to the public about these provisions, or it could collect data to determine whether or not there's an indication that there maybe is another statutory amendment that might be warranted to sort of make this happen further. But right now, under those provisions, I don't think that there's any enforcement piece to consider. There's another provision, 1441, under AB 315. 1441, the new 1441 will create requirements for pharmacy benefit managers to report certain information to healthcare plans or insurers. And again, since the board isn't going to be issuing the licenses to the party, so the board isn't responsible for licensing those PBMs, that's going to fall to a sister agency. Its role may be more of an educational one, of just sort of keeping your thumb on the pulse, so to speak. Finally, AB 315, which creates the regulation over PBMs. The PBMs won't actually be regulated until next year. That's when the licensing scheme over them will become effective in 2020. It's law now, but it's going to take some time for that agency to build up their systems for regulating, I think. But they did create a task force, and the task force is specific to I think it's specifically called the Task Force on Pharmacy Benefit Management Reporting, and that's within the Department of Managed Healthcare. It specifically allows other departments to become part of that task force. So and that had to do specifically, I think, with what information related to pharmaceutical costs that healthcare plans or PBMs are going to be required to report to DMHC. And if that data or that information, the board believes that's relevant, then certainly staff could reach out to DMHC and suggest that perhaps that somebody from board staff be part of that task force.
Well, in a certain sense, I think we have an ethical responsibility to pay attention to this, because this is an access issue, definitely. And so while I'm thrilled we don't have an enforcement requirements for this, I would like to continue getting some sort of information on this from the sister boards and have it relayed to the committee. And I'm not sure what that information will be. I certainly hope that this is adhered to.
May I suggest that perhaps we have the Communication and Public Education Committee look at different education avenues that we can explore to ensure that the information is out there?
Great.
Would that be agreeable?
Great.
With regards to the task force, I think having a representative of staff, the EO position, we probably, I don't know what time constraints there are, but I think it would be certainly advantageous for informational issues back to the board, if not for other reasons, regulations, and that we might be able to put together, but I think it would be a great advantage for the board, and certainly a great advantage for the task force, if the pharmacy board is represented on it.
You actually took the words right out of my mouth, Stan. So I was, on behalf of CPHA, I'd like to request, perhaps even if it needs one, a motion that the board send a representative to this task force. I know CPHA would very much support that as we start figuring out the regulation of PBMs moving forward. So.
Right. And so I think under the way that AB 315 is written, technically the composition of the task force is up to the Department of Managed Health Care. But certainly, and they're a state agency too, and I imagine that any meeting that they would have would be public. So you could request to be on the task force itself, but if not, you would probably be able to attend as an observer.
Are they under the DCA umbrella?
They are not.
Which umbrella are they under?
I don't know.
They're on their own, I believe. If not on their own, I believe they're under Health and Human Services.
So do we need a motion?
No, I don't think so.
Do we? No need a motion, right?
It doesn't hurt to have a motion.
Well, I would like to have a motion to have a Victor to participate in the task force.
You volunteer my service.
Well, because I think we need a pharmacist to be there because you know how the pharmacy operation work on both sides, you know.
I think the EO or the staff of the pharmacy board would be more appropriate because I might not be around that long.
No offense to Albert, but I would make a motion that the executive officer
Turn your microphone on.
All right. It's like going to a shopping market anyway. You got the list, the bag. Anyway, I would make a motion that the executive officer.
Well, you have to vote down my motion before you have another motion.
Oh, I don't think it was second.
I don't think it got seconded.
It never got a second.
I'm sorry, Albert.
Oh, Ryan did second.
Ryan seconded it? Oh.
Ryan did second that one, I'm sorry.
Well, that's not a real second.
The only second.
Yeah.
The reason that I suggest a pharmacist because they know how the mechanism work on the reimbursement, things like that. But I don't think that our EO will understand, those regulations.
Well, the other thing that we have to take in consideration is I think a lot of the time when you submit a claim, there's a requirement that the pharmacy does pass along their usual and customary price. So the PBM quite often has that information. So it might all be able to be resolved with just making it a requirement like what we have here in 1367.47 that applicable, that it's the lesser of the applicable cost share or the retail price. So if you were to send that information, which a lot of all government contracts require that, that you send it, and then the PBM would pass back the lesser of those two to the consumer, to the pharmacy to pass on to the consumer. And then that, just one more sec, and then that takes care of up here. The applicable cost share is now applied to the deductible, and all those other requirements. So if it just was made as, and this goes back to managed care has to do this, but that this would be that's really an easy fix.
To be perfectly honest, our support for this is really on the earlier conversation we had on continuity of care. I think sometimes, particularly with Department of Managed Health Care, they're used to dealing with health plans, not individual consumers. And I think this board would have great expertise, whether it's, and I'm not going to take a position whether it should be the EO or the president, or that's not my purview. But that expertise is definitely warranted for this task force.
The reason I nominate, I motion for Victor. He owns a pharmacy. He familiar with the reimbursement. That's one of our root of our problem, that you don't have a technician, you don't have a clerk work the pharmacy, you have pharmacy work by himself. Like I always said in this board before, follow the money. I mean, how can we work as a pharmacy? You know, when you fill a prescription, you lose money. I mean, when you
I've been
sell a
told that,
cup of
yes.
coffee, you know exactly how much you make. And now we in a situation under the PBM, when we fill prescription, we don't know what we end up with.
That is very,
You
very
make
true.
money, you lose money, or you break even. You do not know that until a few months later, or maybe end of the year. So how can you operate a pharmacy with this kind of situation? So I mean, I don't think the EO will understand how the reimbursement work. So you know, I think even though Victor here is not here forever, but you know, whatever time he's there, whoever continue, he could you know, brief the next one and then continue. But I think we have to pay a little more attention at the PBM.
I feel honored to be nominated, but bear in mind that I am a member. I'm a member of that PBM, and I still want to do business with the PBM, and I'm afraid to go and testify against them. So maybe a person of non-conflict of interest would be more appropriate.
I don't think we need a motion. I think this thing can be handled. We can determine who goes and who doesn't go.
No,
You don't have to name a person in a motion.
Yeah, a little discussion on this, and I think we can move forward. You know, and you could go.
I could rephrase this, so don't have
Just say a pharmacist if you want to do
a
it that way.
person, but it don't have to be a specific person right now. I think we should participate in the task force.
All right.
That's fine.
I think that's agreeable, right? Okay.
So you're modifying your motion?
Ryan, do you agree with that
Yeah,
adjusted motion?
modify the motion. Okay.
So where are we on this?
So Albert modified the motion to just for among the discussions that we will be dedicate somebody to be present there on behalf of the board, either the staff or appropriate person.
So is there a motion on the floor?
This is the motion by Albert, second by Ryan.
That
right?
the Board of Pharmacy will try to participate in this,
In this process.
in that task force.
All right, that's the motion. All right, any other further discussion? If not, all right, other.
Oh, here she
all right,
comes.
one more public comment. Okay, come on.
Thank you. Jennifer Snyder on behalf of the California Retailers Association. I just want to support, obviously, the board's move to participate a little bit more in future discussions with respect to implementing 315. I want to make a comment with respect to both where we're at in addressing the concerns that were raised, both by a letter to the board and also to the authors of AB 315 and 2863. Our concern was that there wasn't a capability for a pharmacy to actually provide the retail cash, retail information to the PBM or the health plan. We've learned since then that under certain contracts with PBMs, as Ms. Veal spoke to, that we do have that capability. So in many instances, we're actually being able to comply with the law. So I want to make sure that folks know in many cases, many instances, pharmacies do have that capability through the already established transaction process with the PBM to provide that information. Our concern is that there still needs to be a little bit more processes in place for health plans or insurers that may not use a PBM, or in cases where a patient wants to provide or pay for cash for a prescription, but not have their health plan know about it. And so we're working with the author to actually try to extend the requirement for 1 year to be able to work that out. I appreciate the board, just stepping back, but also being a participant as we move forward. So we will hope to be in compliance as soon as possible. We're working towards that.
Now, but you know, when you say hold off on this because of these problems in processing, this does not stop the consumer from getting the lower price?
Definitely not. And there is already a requirement in law for the pharmacy to make sure that the patient consumer knows that if the cash price is less, that the cash price is less than their copayment amount. Correct. There's nothing here that doesn't prohibit them from doing it. It's all about the transaction of the pharmacy providing the information to the insurer that the patient paid cash for the paid retail price for the prescription instead of paying their copayment.
Okay, great.
And it doesn't even prohibit the patient from notifying the insurer directly either of that transaction.
Good.
Why would they do that? Anyway.
Great. Thank you.
All right, thank you.
All right, now we go back to the motion. All right, all those in favor, please raise your hand. Unanimous. Okay, motion passed. All right, go on, Alan.
Okay, and you know, this is going to be especially looked at because of the new governor's emphasis on affordability of drugs. And so this is, okay, B, discussion and consideration of amendments to California Code of Regulations, Title 16, Section 1713, related to automatic drug delivery systems. This recently enacted legislation alters the condition under which a pharmacy can operate such a device. With this enactment, the board should consider amending existing regulations for these ADDSs that dispense medications to patients to reflect current law in this. And the committee recommended that the board initiate rulemaking to, rulemaking to amend Title 16, Section 1713, to delegate the executive officer the authority to make technical or non-substantive changes consistent with the board's policy.
Sorry. Let me make sure I'm in the right place. I have one slight recommendation. Rather than have that authority be technical or non-substantive, I would actually recommend replacing that term with clarifying, because we're at the beginning
okay.
of the
Great.
process on this one, and we want to be able to make a substantive change. If we used a term inconsistently and created a conflict, we want the EO to be able to clarify that without having to come back to the full board.
Great.
Okay, so this is a committee recommendation.
Yes.
Any other board members comment? Public comment?
So you're saying leave non-substantive changes consistent with the board policy in place?
I would actually recommend striking the technical or non-substantive and replacing it with the word clarifying,
Okay.
because we're at the front
To make
end.
clarifying changes consistent with the policy.
Correct.
Got it.
I mean, that it would be consistent with whatever the board does here, but
Good.
So are you good, Stan?
gives her the
I'm
ability.
good.
You're good. Okay, any public comment? If not, all those in favor, please raise your hand. Unanimous? Okay, motion carried.
Okay, C, discussion and consideration of possible statutory amendments to clarify cures, a reporting requirement related to dispensing date. Currently, all Schedule II to IV controlled substance prescriptions dispensed in California must be reported to Cures. Records of dispensing must be sent to Cures within 7 days of dispensing, and there's no current requirement to send a void or cancel message for these prescriptions that were filled but never picked up. While the Cures reporting system is administered by the Department of Justice, actual submissions by pharmacy are transmitted to a third party, Atlantic Associates, and they are tasked with data integrity, formatting checks, identifying duplicate entries, and reconciling near matches. They then transmit data for insertion into the Cures database. Additionally, while some pharmacy systems hold the prescription transmission to Cures until the patient actually receives the filled prescription, most do not. Thus, Cures report may contain medication that, in fact, were never actually dispensed to the patient. We had a variety of discussion from Mr. Stein, who has a white paper on this, and he's going to speak about it right now.
Hi, Robert Stein from KGI School of Pharmacy. Yeah, the issue that came up was identified by a pharmacist at a symposium I was at, and he was telling me that another pharmacy had to call his pharmacy to say, I have a patient here who you dispensed a controlled substance to, but he's saying that he never actually got it. And that pharmacist then checked his records, and indeed, the prescription had been filled, never picked up by the patient, but was reported to Cures. So in doing a little bit of digging with some of the pharmacy system vendors and some of the pharmacies out there, there's a big variation in terms of exactly how that process works in terms of what the trigger is to send a transaction to Cures. If you have a system where you have a point of sale scan of the prescription, and that feeds back into the computer system for the pharmacy, that would potentially be the best practice from the standpoint of then it is dispensed to the patient, it's sold to the patient, it's pretty clear. But there are pharmacies that process the prescription, generate a label, and during that adjudication with third-party payers, that's when they send the transaction, or that's the trigger to send the prescription to Cures. If that sits on the shelf and never gets sent to the, never gets given to the patient, when it's returned to stock, there's nothing in most of these systems that actually will generate a reverse transaction to Cures. So you'll reverse the transaction for the charges, you'll reverse the inventory correction reflecting the drug returned to stock, but Cures still thinks that that prescription was out there. This can impact patient care in a negative fashion from the standpoint that a subsequent prescriber looking at a Cures report would be under the impression a patient was taking something that in fact he or she never received. So it is an issue that needs to be addressed. It apparently isn't just limited to California Cures system. It seems to be with PDMPs across the country. So what we're really looking at is making sure that the law requires pharmacies to understand that they need to send a reverse transaction when in fact a prescription is not received by the patient. The other part of this, which is something that both CSHP and CPHA are jointly going to be sponsoring, is legislation to address this particular issue. So it would involve, let me see which specific sections, 11164.1, 11165, and 11165.1, adding Schedule 5 controlled substances. And I know that LegReg is going to talk about this a little bit later, but we're definitely in support of adding Schedule 5s to the Cures system. And then amending 11165 to make sure that it's clear that when a patient doesn't receive the medication, that a transaction cancellation, if that transaction had been sent to Cures, needs to be sent to the Cures system.
Thank you. Danny?
Just adding that, as mentioned in the LegReg committee this morning, this is the joint sponsored legislation that I was referring to. Bob pretty much nailed every piece to this, and looking forward to hopefully working with the board on this.
Now, how much effort is it to reverse that to Cures?
Well, if the system doesn't do that, there's a manual process, and how it was described to me was the pharmacist had to contact Atlantic Associates, get some information, actually write out a file, send that file along with an email to the Department of Justice, and in maybe 2 or 3 months, it would actually get expunged from
So
Cures.
pretty straightforward, timely. Yeah, okay,
Right.
good.
So, but the script protocol that sends data from the pharmacy systems to Atlantic Associates does contain the capability for this reverse transaction. It's spec'd out. Okay. So just having the systems be able to do that, or hold sending anything to Cures until the point of sale, if a system can do that, either of those two solutions will obviate this issue.
Great.
Thanks.
Okay. Any further discussion on this?
Yeah, it's important to do that. Right now, a lot of pharmacists have the same issue, and we have the same issue too. We can reverse those to Atlantic. And so the Cures report will have those data for the patients who never pick it up.
Okay, For further edification, attachment 14 has Dr. Stein's suggestions there. Okay. So D, discussion and consideration of the board's enforcement statistics. Since July 1, 2018, the board's received 1,398 complaints and closed 1,406 investigations. I was just staying ahead of the curve there. And as of December 31, the board had 1,893 investigations pending. Since July 1, 2018, investigations unit closed 643 complaints without substantiated violation, including 162 complaints that were determined to be non-jurisdictional. I assume those are from the public and they don't fall under the Board of Pharmacy? Is that what we mean by non-jurisdictional?
Yeah,
Yep.
it's typically from consumers. Sometimes it's from another agency, and they're just not sure where to send it.
Oh,
so then
okay.
we will refer it on.
Okay. And then since July 1, 2018, the board issued 709 citations, 107 which the board offered abatement or other ways to reduce or eliminate the fine. And the board referred 125 investigations to the Office of the Attorney General. As of July 1, 2018, the board resolved 120 administrative cases that resulted in 107 revocations or surrenders, 53 licenses being placed on a probation, and 20 public approvals. These enforcement statistics are in attachment 15. Future meetings will take place on March 14th, July 2, and September 25. End of the 13-page enforcement chair report.
Well done.
New indoor record.
Thank you very much, Ellen. Well, that's a big job to do. And I think right now we should take the lunch break before we start the special meeting. Why don't we reconvene at 2 p.m.? Okay? Thank you.